Labas rytas.
Good morning, ladies and gentlemen, honorable participants of the conference and guests. We are sorry for this short delay. There are big queues at the entrance to the parliament. We have gathered here today at the hall of the Constitution of the Seimas and the Tax Dispute Commission, together with the Seimas of the Republic of Lithuania and Vilnius University, is organizing the Scientific Practical Conference for the fourth time already. So this event, which merges the tax practitioners, it brings together lawyers, economists, and starting of last year, this event became an international event. Today, we also have international experts in our conference. We have guests from Ireland, and we will hear a presentation by a chairperson of the Tax Appeals Commission of Ireland. And I would like to give some technical details. This conference is being broadcast online, both in English and in Lithuanian. For Lithuanian broadcast, you can see it on Open Seimas website and the Tax Dispute Commission's YouTube channel. And for YouTube, you can only watch it on the YouTube channel of the Tax Dispute Commission. And this year's topic is taxes and disputes, where we can improve. In this conference, we will be talking about relevant aspects and the trends, the problems, the challenges that we have, what we can change in this area so that we have more clarity in taxes and, fewer confusions in the tax area. So it brings together, just like I mentioned, academia, practitioners, lawyers, and economists. So now we've invited representatives from various walks of life to give their welcome address. So first of all, I would like to pass the floor for a welcome address to the representatives of this house, starting with the chair of the Seimas Finance and Budget Committee, Algirdas Sysas. Ladies and gentlemen, as a host, I have to apologize for this short delay. But, it's trendy in Lithuania to say nowadays that, security comes first. We were not attacked by balloons or drones, but our security takes their duties very seriously and they control the access very strictly. So we will try to not to take too long with our welcome speeches, and I believe that we will catch up with our agenda. So it is a great honor for me to say those few words of welcome. I have heard about taxes and disputes, but I did not take part in it. I pay my taxes, but I did not have a chance to dispute. I welcome the guests from Ireland. Sharing experience is always useful, and it's useful for all sides. So first of all, I would like to thank the partners and the Tax Disputes Commission for the program they have prepared, for their annual contribution to organizing this event. Our Budget and Finance Committee not only cares of how much taxes we collect, but also how those taxes are administered. The tax system is probably one of the key systems which builds trust in state. Therefore, taxpayers have a right to proportionate, fair decision-making, and it has to be ensured formally and officially. And the tax-paying function is very important in protecting taxpayers' rights, because we all understand that the state is always the stronger side in all these disputes. As the chair of the committee, I would like to learn the following things in this conference: where the legislation is lagging behind from practice, because we often are blamed for this; where administration practice causes greatest tensions for taxpayers; and where we need to improve the cooperation between the institutions in order to have fewer disputes and to have more clarity. What we care about is that those tax disputes, so that they don't become a formal approval of something that has been decided by the tax administrator. The statistics of tax disputes raises serious questions about the balance. More than 90% of disputes are resolved in favor of the national tax administrator. I don't know if we should congratulate them for their good job, or if it's something that we should question. And only 10% of those disputes are resolved for the benefit of the taxpayer. So we have a reasonable question to ask. Do we really have a realistic, practicable possibility to defend ourselves against the state in tax disputes? So, honorable participants, seeing such a broad agenda, I would like to wish you all productive work, inspiring debates, and many benefits and new ideas for your personal development. May this conference become a new step to a clearer, more transparent system based on trust. So I would like to thank once again all the participants and the organizers and our partners, the Tax Dispute Commission and Vilnius University for this event, which builds a platform for dialogue. Thank you. And now I would like to invite the chair of the Law and Law Enforcement Committee, Julius Sabatauskas. Good morning, dear participants of the conference, speakers, colleagues. Well, my colleague has already mentioned what are the difference between the practice and the legislation, and what gaps we have in legislative process. And I will mention a few of those gaps. So welcome to you all in the parliament, in the Seimas, the place where decisions are made which define our legal certainty and economic environment. Today we are talking about tax disputes, the topic which may seem at the first sight as rather technical, but that is one of the key pillars of trust between business, society, and government. Tax dispute resolution is not only an expression of the rule of law, but is also a guarantee that we have clear rules, the disputes are dealt with in a quick and transparent manner, businesses' rights are ensured, and sufficient revenue is generated. But when we have uncertainty, there are ways to interpret legal norms in different ways, and we still have this vacuum and these gaps in Lithuania, especially when it comes to VAT, to various tax exemptions. So this situation determines that our courts and tax dispute commission have to deal with various contested matters, even though it has to be the competence of the legislator. So the facts show that the practice is changing, and the Lithuanian Supreme Administrative Court makes decisions every year which really change the interpretation of tax disputes. And the Tax Dispute Commission in 2024 made a record number of referrals to European Court of Justice. So this means that national practice is not stable. Case law, is not stable, and it keeps evolving. And it is really affected by the EU law. And that is, of course, positive. On the other hand, it it causes other problems. And we see similar challenges in other EU member states. In Germany, France, the courts also are building a similar case law, and legislators respond and try to eliminate those gaps. In Ireland, after the Apple case, the clarity was strengthened in avoiding certain gaps. Smaller states such as Malta, Luxembourg, have fewer disputes due to simplified system. When those disputes arise, interpretation questions become essential. So overall trend is that national courts refer to the European Court of Justice more often for preliminary rulings in order to resolve the legal vacuum and ensure equal standards, legal standards. So one of the biggest examples is the Apple case. The European Commission requested Ireland to claim 13 million euros in unpaid taxes. And this shows that European Union is strengthening their fight against tax evasion, and that is a signal to all states that national policy cannot go against the competition laws of the EU. And this precedent has not only changed strategies of technology giants, not only in Ireland, but elsewhere. And our state has to deal with different challenges today, but that is the topic of some other conference. We have to tackle fraud, disinformation, and that is the impact of social media giants, the pressure that they make. So we have to maintain pressure on them. I think this is something which is not related to this conference, but I simply wanted to mention this, that this problem exists in many areas. So, dear colleagues, this conference is intended not only to discuss practice and trends in Lithuania and abroad, but also to look for answers, how we can ensure legal certainty, clarity, which is prerequisite for investments, for our citizens. And may I wish you constructive, business-like debates, good ideas which can really help Lithuania advance and make progress in legal certainty. Thank you. I'm sorry I cannot stay long in the conference because we have some other conference happening in the houses of the parliament, so I will have to attend other events as well. Thank you, Honorable Chair. Now, I would like to invite the partners of the conference, the Dean of Vilnius University Law Faculty, Haroldas Šimkūnas, for his welcome address. Honorable members of the Parliament, colleagues, ladies and gentlemen, as law faculty of Vilnius University, we have a great honor and great pleasure to be a part of such a serious, important event. And we are doing this for a number of years, so we can already say that it has become a traditional event where we have useful and interesting and inspiring debates. I believe that, namely at this conference, at this event really has a bright and beautiful future because we have a nice community wrapped up around this event. We continue our discussions on these important matters. Every time you have to address a conference, to give a welcome address, you feel really nervous and anxious, especially if your area of interest is not necessarily linked to the topic which you have to address the conference on. So I am the expert of constitutional law, not of tax law, but this event is hosted at least in the Constitutional Hall, so this makes it easier for me. So this at least makes me feel more cozy. But to speak seriously, well, there is a very well-known saying by Benjamin Franklin about unavoidable things, and there are two of them. So I think it relates to something that Einstein has said as well, about two things which are endless or limitless. Well, tax is not something that is endless. Taxes, like death, are unavoidable. And this is what I thought about when getting ready for this speech in my mind. We can always develop ideas. We can try to put forward certain ideas. But disputes probably are unavoidable as well. You cannot avoid those disputes. And there's third thing that you cannot avoid. Mr. Benjamin Franklin, you haven't noticed this, that something is unavoidable. So since disputes are unavoidable, let's see what impact and what benefit they have. A dispute on its own is not a very good thing, but if you deal with it well, so it may have positive consequences. And if we take a look at our history, and if we take a look at the very ancient times, since in the ancient times, the property law is innate law, inherited law. But when you need to collect taxes, and states always have to collect taxes, then the question arises of how to do that, how to collect those taxes, and why the owner has to pay those taxes, why the owner who has a property right and why it is being threatened. In the 13th century in the UK, it has raised so much tension that the king was forced to hold parliament, to have a parliament, and you know. So this institution that we are sitting here today, it has come from the parliamentarian tradition of England, and it was an attempt to build a fair procedure of taxation. Because why we need to pay taxes, which may mean the offense of the property right. So how we deal with those disputes? Is there a space for improvement? Well, probably if everything was fine, we wouldn't be talking about this. Aristotle in the past has said many smart things, and he has built a beautiful theory of justice in the past, which is also a good foundation for many scientific research of justice today. So justice may be specific, but we have to be very cautious with the application of justice in a particular situation. We have to use a certain specific sort of justice for some specific case. Equal shares for equal participants, or, well, there are various nuances related to this. And well, maybe I'm not speaking exactly on the notions of Aristotle in my speech today, but I believe that there will be some links with certain theories of justice built by Aristotle, and probably that will be an inspiration for me to move forward. One more thing that I would like to mention. I have heard what Honorable Chair of the Budget and Finance Committee has said. Maybe that number, 90% of cases which are resolved in favor of the tax administrator, it may be seen in different light. I understand this, and I agree with him. Since Tax Dispute Commission is our partner, I know that their decisions and their stability decision indicators are above 90%. So for them as an institution of pre-trial in dispute resolution institutions, I think it is a very good result, even though that those results can be, those decisions that they make can be appealed against. So that is another topic for discussion. I see that we have representatives and judges from administrative courts in our audience. If I were in your place, I would be happy with the work of the Tax Dispute Commission because they are making your life so much easier. So this means that they are doing a very good job. So that I wouldn't seem rude, and I know that we are a little behind our schedule, and we want to catch up with the agenda that we have. So I would like to conclude my speech. I don't have a presentation to make, so I would like to wish the Tax Dispute Commission to keep their bar raised as high as they have it now. So please stay as high as you are. And may I wish all the taxpayers who pay taxes to pay taxes and feel that we contribute to the growth and welfare of this state, that we contribute to strengthening our legal state. And may I wish all the participants of this conference interesting discussions, useful ideas. Every time we leave a conference, we take away something. Even coming to the conference already has some benefits. So I hope that your takeaways from today's conference are rich and inspiring. Thank you for your attention. Thank you, Mr. Dean. So through tax disputes, we are building our case law. We develop certain legal certainty and clarity. And I would like to encourage you all to make use of this opportunity to assess the situation independently and from different perspectives. Well, if we go back to the statistics, in order to present proper statistics, we have to include all the tax disputes. But according to our calculations, we don't approve some 40% of the tax disputes, decisions made. Tax dispute decisions, I'm sorry. And for that, legal certainty, our courts are crucial and their role is vital, so especially the Supreme Administrative Court. And now I'd like to invite Professor Žalimenė, who is the chair of the Supreme Administrative Court of Lithuania. Thank you very much, honorable participants of the conference, speakers, colleagues, guests. I'm very happy with this opportunity to welcome you at today's event, a traditional event, a scientific practical conference, which is intended on taxes dispute. I would like to thank the Tax Dispute Commission for this invitation and for initiative of this important conference. For bringing us together for the fourth time, bringing together the lawyers, representatives of the academia, practitioners, and representatives of various institutions. The topic of today's conference, tax disputes and where can we improve, well, calls us to take a broader look, not only to discuss changes in scientific or case law practice, but to look for new ways, effective ways of cooperation between the institutions, between the academia and practical system. And only this kind of partnership allows us to develop a system where justice is implemented and builds a proper justice culture. Tax disputes they form a significant part of our case law, and we have to deal with hundreds and hundreds of tax cases in our work. And the agenda of the conference shows the multifaceted aspects of this topic, from case law in the tax disputes to international perspectives, It all shows that tax law is dynamic, ever-evolving area, which requires not only thorough legal knowledge, but also ability to adapt to economic topicalities and EU law developments. During the conference, we will deal with very serious practical aspects, such as zero VAT rate, customs requirements, possibilities for tax disputes. So this shows that our activities do not only limit with practical aspects, but it also has an impact on investments, on economic activities, and economic stability. I'm happy that today we will hear about the international practice. The model of Ireland will be presented, learning from other states and from the practice of other states. International cooperation and the search for good examples is important in order to improve our national system. Administrative justice is not only limited to national level. We are an inseparable part of the European justice system. And I believe that today's discussions will be constructive, meaningful, and only by acting together, by sharing our knowledge, by analyzing the practice and looking for best solutions, we can ensure that tax disputes and handling of tax disputes is in line with the top standards and maintains proper balance between the fiscal interests of the state and the taxpayers' rights protection. So let me thank the Tax Dispute Commission and all the organizers of the conference for their initiative to bring together experts and to build a platform for constructive dialogue. And may I wish that this day is fruitful, full of lively discussions, good insights, and attempts to strengthen our rule of law and ensure proper law application in tax disputes. Thank you. Thank you, Honorable Chair of the Court. May I now invite Vice Minister of the Ministry of Finance, Darius Sadeckas. Ministry of Finance, just like Ministry of Justice, is directly linked to a legislative process and regulation of tax disputes and legislative initiatives in this area. Good morning, colleagues, guests, participants. I'm happy to address you in this event. In my opinion, this event is a wonderful example of how shared efforts of institutions, business, academia can build a platform for dialogue where we can share our experiences and look for better ways to address tax disputes. I believe that quality and effective resolution of tax disputes is one of the key elements of a reliable tax system. It helps us maintain proper balance between protecting taxpayers' rights and financial interests of the state. It also contributes to better trust in state and encourages fair and honest tax payment, which is very important for us. So I believe that it is important to foster this area even further. And the environment in this area is ever-changing. Case law is changing. New economic, technological factors emerge which pose new challenges, and they require a more flexible approach. Events like this give us an opportunity not only to assess how far we have gone, but also to foresee certain steps in the future so that our tax system and tax dispute system remains clear and reliable. So I'm truly grateful to the organizers for this traditional initiative, traditional event, which is hosted for the 4th time already. And I would also like to thank all the participants for their active engagement and participation. So I wish that the presentations you will hear today are inspiring, useful, and would encourage our willingness to improve and become better at dealing with tax disputes in Lithuania. By doing so, we also strengthen our international cooperation because we have colleagues from Ireland. I believe that this dissemination of good practices is very important for our improvement. So may I wish you a successful and constructive conference. Thank you very much, Vice Minister. Now we still have a representative on another ministry, Barbara Aleškevičienė from the Ministry of Justice. She's the Vice Minister. Honorable participants of the conference, guests, I'm very happy with this opportunity to welcome you on behalf of Rita Tamašunienė, the Minister of Justice. I'm happy to see so many experts of this field, representatives of academia and practitioners. Tax disputes play an important role in the system of administrative disputes, because this is the area where public interest protection and private rights collide. And it is obvious that the greatest achievement in our administrative justice system is the possibility to resolve these disputes before going to court, because it reflects the ability of our state to ensure effective, accessible, and fast justice. And we are happy that the statistics show that Tax Dispute Commission is relied upon, is trusted. The number of decisions made by the Commission is growing. This shows that they are working in a good manner. We also have some more figures to illustrate. They are doing a titanic job, and that is the effort that you all make to find a compromise between the public interest and the human rights, the citizens' rights. The Ministry of Justice is now planning to renew the debates on pre-trial dispute resolution possibilities, and we would like to invite you all to discuss and assess the possibilities to expand mandatory the categories of mandatory pre-trial dispute resolutions. We all understand how important the dialogue between the academia and the practitioners is. And I'm very happy that today, during this conference, we all meet and we are all united by the same goal: to strengthen the protection of our citizens and to ensure effective justice. I would like to thank for the invitation once again, for this possibility to speak, and may I wish you meaningful discussions during today's conference. Thank you. Thank you to the Vice Minister of Justice. I will now pass the floor to the moderator of the first session, attorney at law, Dr. Mindaugas Lukas, who will moderate the first session. And Povilas Gruodis will moderate the second session. During the first session, we will focus on those disputes itself, on the case law, while the second part will focus rather on tax and tax problems. So now I pass the floor to Dr. Mindaugas Lukas. Good morning, everyone. Thank you to the organizers for this honor and responsibility. I have my watch next to me, so I won't take long, and would like to invite the first speaker, our guest from Ireland, the chairperson of the Tax Appeals Commission of Ireland. 1,711 disputes they have resolved in 2024. That is a huge amount indeed. So we would like to invite Mary Clary Many.
Labas, Eritas. Apologies if I'm not so good. Chairperson Wilma, honourable members of the judiciary, honourable members of Parliament, Dr. Lucas, ladies and gentlemen, I am honoured to be invited to Vilnius by your organisation. I understand the theme of the conference is taxes and disputes. Where can we improve? So I have taken your theme to heart and will speak today about how my organisation, the Tax Appeals Commission of Ireland, has transformed and improved. Referencing a previous speaker, Aristotle also said, "We are what we repeatedly do." So today I'm going to talk about what we repeatedly do. The presentation will take the following format. I will briefly explain my role as the chairperson, then explain the functions of the Tax Appeal Commission, provide some historical background, which is complicated to say the least, and then explain what and how it was transformed, and then finally set out where we are now and the future innovations we are considering. So my own role, which is set out in statutory provision, and my boss is the equivalent of this man here, the Minister of Finance, and I am responsible for the finances of the organisation, the operations of the organisation, the risk management, and all the legal compliance. It is a demanding, but hopefully rewarding role. The Tax Appeals Commission itself is an independent, quasi-judicial statutory body tasked with providing a modern and efficient appeals process in relation to the hearing and adjudication of tax disputes. The appeals relate to decisions by our tax authority in Ireland called the Revenue Commissioners. They are tax and customs cases, especially where revenue raise assessments or charges to tax or duties against individuals, partnerships, companies, and all organisations that have a tax or duty liability. The challenge for the Tax Appeals Commission in Ireland is that the appeals range from very small amounts, for example under €50, to very large amounts. The highest quantum of appeal that we have adjudicated on was a mere €568 million for one case. The high quantum appeal cases are due to Ireland's tax base and the significant number of international companies who have their head office in Ireland. These include many pharmaceutical and, as a previous speaker referred to, information technology companies. The Tax Appeals Commission commenced on the 21st March 2016, and over 2,000 appeals were transferred from a previous body called the Office of the Appeal Commissioners. But for the first few years of its existence, it had a very checkered time and unfortunately was not a successful organisation. Hence, why the role of chairperson was introduced and I was appointed in 2020 to transform the organisation. So what have we done since 2020? Since 2016, it has received 14,694 appeals at a value of €8.8 billion. It has closed and resolved 14,118 appeals to the end of October 2025 at a value of €8.3 billion. So that's €8.3 billion, which the Minister for Finance might want, that we have released back into the economy or to the Exchequer. Our appeals currently on the books, or what we call on hand, is 576 at a value of €0.5 billion. It is now a very successful organisation, I am proud to say, with an esteemed reputation. However, it was not always so. Prior to 2020, it was rather Dickensian, and would have reminded any user of the book Charles Dickens' novel Bleak House. Charles Dickens' novel Bleak House is a satire, an indictment of the legal system. For all the lawyers in the room, they will know that. Dickens used a fictional case called Jarndyce versus Jarndyce to demonstrate a system that was utilised to perpetuate disputes and in itself rather than resolve them. And that was certainly an element of the work of the Tax Appeals Commission prior to 2020. Everything was in the red. Too many appeals, the quality of the output was suboptimal, and the quantum under appeal was significantly high and a worry for the Exchequer and the Minister for Finance. There was a backlog of awaited determinations, and in July 2020, when I joined, the number of appeals was 3,600 and the quantum was over 4.2 billion. The case management was not fit for purpose, the staff were under-resourced, there was inadequate hearing and IT facilities, inadequate governance, and the website and the documents for the public were not user-friendly. Lots of obstacles to success, including outdated IT, masses of paperwork, and all this in the midst of a global pandemic. So how did we transform? Well, we looked at systems, the structure, and that positively impacted the sentiment in and towards the Commission. So first looking at systems and the technology updates. And the Commission has invested heavily in technology. We purchased polycoms and cameras, and now over between 30 and 50% of our hearings take place remotely. And we have attendees from all over the world. We digitised all files and are now a paperless office. We have cloud computing for digitised bundles of documents for hearing. We invested in robotics and redesigned our documents. We also invested in voice recognition software, which works very well. In addition, we upgraded our website with a search facility. We have introduced a classification of appeal determinations for easier access of information. There's links to all the decisions over the years, tax type and legislative provisions. And our website is now in both English and Irish for those who speak Asgaelga Irish. The public can now submit an appeal on a portal, and that application is automatically opened in our new case management system and assigned a new number and acknowledged. And I am happy to say we are now receiving about 80% of our appeals via this digital portal, with the rest sent on email or the old-fashioned post. And I just show you here some snapshots of what the case management system looks like, which you won't be able to see from here, but it just gives you a demonstration of how it looks. We've redacted the information for confidential reasons, and that's at the touch of a button what everything looks like. And if we want any statistics of where every appeal is, and any statistics that I would want as a manager, those can be got again at the touch of a button. So we're very, very pleased with our system. We also looked at the system in terms of governance of appeals processing. And it was important to ensure that once an appeal is lodged, it is progressed efficiently and there is good governance around such processes. Hence, I have overhauled our operations and introduced an operational manual and a significant number of new processes and policies. These have included a scheduling policy, a stay policy, a dismissal policy, a redactions policy, an acceptance of appeals policy, a publication policy. It goes on and on. We have also introduced templates for decisions and determinations so there is consistency in the format and quality of our work. We also changed how the appeals pipeline works so that each appeal commissioner has a caseload from the commencement of the appeals and manages their own appeals. This means they know the appeals from the start. We have also assigned the Commissioners targets and timelines to complete decisions and determinations, and these are monitored closely. We also have regular legal updates for the academics will be pleased to hear, where we discuss the judgments of the superior courts. After systems, we also looked at the structure of the Appeals Commission. And in order to match the case base, I restructured the Appeal Commissioner cadre, so it is now in tiers, based on the value and hence complexity of the appeal. In Ireland, there is no other quasi-judicial body, or even a court, dealing with such a range of cases, from the volume of the small claims court, the small cases, to the complexity and quantum of cases of our commercial court, and everything in between. So we restructured, and there are now 8 appeal commissioners and 24 staff. The 8 appeal commissioners are divided into senior appeal commissioners dealing with appeals of any value, and then ordinary appeal commissioners dealing with appeals up to 10 million in value. All these changes have meant that we deal with everything in real time, and we have no backlog of work. Everything, I'm happy to say, is now in the green. With these changes, it is important to know that we are being efficient in terms of the closure and resolution of disputes. So each year we have conducted an exercise to assess the delivery in terms of the average time to resolve and close appeals. And you can see the progress that we have made. For 5.4 months in 2022 to the figures at the end of August when we last did this exercise this year. And we would predict that at the end of the year we will have maintained the productivity of 1.8 months on average to close appeals. For those who like numbers, we thought we'd just set out the results to date this year. So as you can see, we have received 995 appeals this year at a value of €639 million, and we have closed out 1133 appeals at a value of 505 million. So that's 505 million, again, back to the economy or the exchequer. We have issued 214 determinations and scheduled 233 hearings at a value of 494 million. I won't go through this slide, but this slide sets out, for those who are interested, how we closed the appeals in 2025, and we keep a very watchful eye on those statistics. And all these are drawn from our case management system at the push of a button. We set out even further statistics. Again, I won't go through them, but these give the breakdown of the types of appeals we have on our books. You'll see the VAT cases, corporation tax, and the quantum. We cannot progress all the appeals, as there are appeals that are related to other matters in the courts or await the mutual agreement procedure MAP process, or other issues such as probate, as an appellant is deceased. So from these statistics, they show that of the 576 open appeals, we can only progress 377. So that is our workload. So I'm delighted to say that we have gone from 3,600 appeals in 2020 to now 377 appeals that we can work on. So that's a 1,000% reduction. And again, for those that like numbers and statistics, this man's writing furiously, we set out the breakdown of the quantum and how those are split for those appeals that are on our books. And you can see that of the 576 open appeals, that we have 134 appeals less than €1,000, but we have 14 appeals at a value of between 10 and 50 million. I'm happy to say we don't rest on our laurels, and we continue to innovate. We now have Windows 11, and we have just upgraded to new cameras and sound quality in the hearing rooms. We are investing in artificial intelligence for legal research to assist the appeal commissioners. We are currently conducting a review of our website to make it accessible to those with disabilities to ensure compliance with the EU accessibility directives. The future looks bright for us, and we have some further changes and challenges. Due to a case in the Irish Supreme Court, the Supreme Court gave a judgment that all tribunals and quasi-judicial statutory bodies must have all hearings in public unless there are special circumstances, and that is a change for us. So new legislation is going through the system, providing that all tax appeals must be in public, not in camera, unless, as I say, there are special circumstances. This will have significant implications for the public and the Commission. Finally, I want to thank you all for listening, and I think you say ačiū.
Thank you very much. Very impressive. Labai įspūdinga. One quick question. Maybe I missed, but the number of commissioners that deal with that amount of cases?
Eight.
8?
Yes.
Okay. So that's what the system can do. Effective system of case management can empower 8 people to deal with that.
Yeah, we had previously, this year is the only, we had 5, but we recruited this year, we're now up to 8.
Okay. Ačiū.
How many staff do we have?
24 staff. It is very, very small,
Įspūdinga.
but everybody works very hard. I am a demanding boss.
Ačiū gerbiamai pranešėjai.
Thank you very much to the presenter. And with this question about staff, I wanted to give the floor to our next presenter, Veslava Ruskan, Judge of the Supreme Administrative Court of Lithuania, who's resolved quite a lot of case law cases in Lithuania. The floor is yours.
Good morning, everyone. Today, I would like to speak about the tax cases and certain procedural aspects that we have to encounter in the activities of our court, that is the Supreme Administrative Court, when we have to deal with tax cases, just like other administrative cases. And since the topic of today's conference proposes the question, what we can improve, so I will allow myself to give certain proposals on what can be implemented practically at a low cost, and I will also propose a certain legislative improvements. Since the court is a conservative institution, so I will not have many of those proposals. When it comes to tax disputes, we have a definition in the law what they stand for, so we don't really have major disagreements on the definition. So if the decision by the tax administrator has been made on the calculations of the tax, and if the tax administrator refuses to refund the overpaid amount, and we also deal with tax disputes if the taxpayer is not exempt from payment of fines or late payment of interest. So, but what cases are not classified as tax disputes? So here, our case law has to deal with certain procedural issues. In the beginning of examining of case, it depends how tax administrator's decision can be appealed against, and if it can be appealed against, and if this claim should be filed to the Tax Disputes Commission, or should it be filed to the Administrative Disputes Commission or the court. So there are many entities involved which may deal with the case, and sometimes it causes disputes in the case law. So it brings us to the fact which actions can be considered as the subject of the administrative case. So both tax disputes commission, which is dealing with the toughest tax disputes, which indicates to pay certain taxes and instructs to pay taxes. Both the Commission of Administrative Disputes, which deals with many other disputes, and Regional Administrative Court, they always have to to answer all of the above questions at the stage of accepting the appeal, whether all the prerequisites exist, and if the relevant authority, if the claim has been referred to the relevant authority, and what procedures should be met. So we have to follow the prescribed procedure. Just like I mentioned, we have a definition of tax dispute in our law on tax administration, while our case law makes the decision on what action of that tax administrator is, which can be appealed against by the taxpayer, and that is not seen as a tax dispute. And any minor action which is not a tax dispute, then we have the rules for this in our case law. So I will be brief because we are behind the schedule, and I will mention what we see as the things that you can refer to court and when you cannot. According to the practice of the Supreme Administrative Court, actions that cannot be appealed against, first of all, they are, a general definition is that those which do not have legal consequences, and those interim procedural decisions which do not result in independent consequences on the taxpayer. Back in 2011, Lithuanian Supreme Court has defined the main criteria of what cannot be appealed. And those decisions and actions are most often the ones which are made during the tax inspection, and those are the decisions which are adopted in the course of the tax administration procedure, and the decisions that are not final and they do not conclude the tax administration procedure. And we also have a claim that if the taxpayer does not agree with such procedural decisions, they may present their arguments in disputing the final decision of the tax administrator. In the very same case, certain criteria have been defined of what can be appealed against according to our case law. And some significant decisions by tax administrators which result in certain material legal consequences, such as instructions to credit institutions, let's say, like resulting in seizure of property, and which really result in serious legal consequences, so they can be appealed against to the court. Or some other decisions which are not necessarily linked to material limitations, but they limit taxpayers' rights in a significant manner, or the right to suspend tax inspection. And if the tax inspection has been suspended and did not take place for a long time, so these are the decisions which are significant for the rights of the taxpayer. So they are admitted in the case law that they can be appealed against. But for instance, the requirement to suspend a tax audit when it is complete, so it cannot be appealed against. Tax administrators' decisions which initiate a tax audit cannot be appealed against, and interim decisions, audit decisions, cannot be appealed against. It just the same like in other administrative cases. If every decision initiating the case would be appealed against, so it wouldn't be reasonable and it would extend the period of that tax procedure. We all know this, but sometimes we forget, and sometimes, let's say, the audit report is being appealed against. But now we have fewer and fewer cases like this. Then the refusal to extend the deadline for submitting comments on the inspection of reports cannot be appealed. Then the proposal to submitted to taxpayer to correct errors also cannot be appealed against. But some let's say notifications, like the refusal to carry out certain actions by the taxpayer, they are subject to appeal. A reminder to pay taxes voluntarily is also one of the documents that cannot be appealed against. And the same applies to requests from the competent authorities of a foreign state to recover tax amounts. And those decision of a tax administrator cannot be appealed given the current case law that we have. People also often complain about the actions or decisions where they are asked to submit certain documents. So these decisions, based on our case law, are also considered as the ones which cannot be appealed against. So this has a purpose not to interfere with the tax audit. And as when it comes to arguments, the taxpayer can file their arguments when appealing against the tax administrator's decision calculating the taxes. Our case law also includes the documents which extend the period of tax inspection or tax audit, so they can also not be appealed against. And this list of the documents and decisions that can be appealed and cannot be appealed against is not final. We have a long list, but there are also decisions and documents that are not included into this list. They are, and I believe that is a natural thing in the operations of administrative court. The same applies for other administrative cases. The same has been said by the General Court of Justice of the European Union. And we took over these practices from that court. and you cannot really define everything that cannot be or can be appealed against. So the same principle applies for tax disputes and tax cases. We have this list where just like I mentioned, we have the guidelines that any decision which is not relating to the calculation of taxes can be appealed against. Just like I mentioned, we have defined what are tax disputes, but we do not have a final definition of what are not tax disputes. And we have the law on tax administration. One of the latest articles, 104, paragraph 1, which defines that in order to ensure that undeclared tax obligations are fulfilled, the tax administrator has the right, in accordance with the procedure established by the central tax administrator, to determine the taxpayer's liability by its decision if the taxpayer fails to submit the relevant tax return in a timely manner. So we had certain disputes in our court activities, and we have to face these challenges on what is and what is not a tax dispute and which institution has referred to in order to appeal against this decision. And the tax administrator, let's say, imposes this obligation after the tax inspection. The court refused to accept this one of the cases, and it has concluded that it has the tax dispute nature, while and it has to be referred to the tax dispute commission. The arguments behind this refusal are defined in the law on tax administration. Whether there were grounds for applying this Article 104 or not, in the case and during the examination of the case, that was really the matter. And so I would like to raise the question maybe, or to ask for your consideration, if this question is so specific and really tax related. Well, as far as I have to deal with the disputes, so usually there are arguments stated as to the essence or the point of the tax. I'm not sure what the case law will be, because we don't have any procedural decisions regarding the assessment of this decision and what would be the limits of its examining. We don't really have the case law in this area. But the questions raised deal with taxes. Let's say now we have the sensitive matter regarding smuggled cigarettes. So tax administrator is not carrying out the tax audit, but without any audit or inspection, they make a decision, and this decision can be appealed to Tax Disputes Commission or the court. So I'm not sure if really this matter is so specifically tax related, but according to the definition of our law, it says that it can be appealed against like any other action. Is it really grounded and logical? And why this dispute is not referred to the Tax Dispute Commission? So I think this is something for us to consider. Maybe we should define it somehow differently in our legislation. Okay, let us move on. another procedural issue which arises in court proceedings when the taxpayer makes several decisions regarding one of or a few taxpayers. I try to put certain examples in personal income tax. When spouses are subject to taxes, I think during some preliminary ruling, of the Supreme Administrative Court, the case law started that the court adopts two equal decisions. Let's say when spouses are subject to personal income tax, and then those cases are dealt with as two separate cases, and that tax is divided based on the civil principles of the civil law to both spouses. And those two individual cases are examined by the tax administrator, and then they are appealed against either to the Tax Dispute Commission, because it is a true tax dispute. And again, they are examined individually. So these are two identical cases, and they come to court as two separate but identical cases. And you can't really know, that it is a case, a similar case, and sometimes you only find a small reference that this similar case relating to a spouse has been examined with. So maybe we could resolve this with our electronic case system. Yes, we have an electronic case system. It works pretty well. But it shouldn't be a coincidence that a case, a court finds these two similar or identical cases, and they have to be resolved in the same manner. So shouldn't we have some provision in our law on personal income tax? If, let's say, if the spouses, if the taxpayers are spouses, or if there are several taxpayers, not one, as we have defined in the tax administration law, and or the law on personal income tax, because we have this practical misunderstanding. Sometimes those cases are examined in the same way, sometimes they are not. So sometimes we had to renew the proceedings under the extraordinary measures in order to ensure equal practice in identical cases. So these are simply practical suggestions. If we have two identical cases examined, so it cannot be that, it's simply by coincidence this fact is defined. It has to be clearly stated. Maybe tax administrator could deal with those two identical cases and make those two decisions, or make simply one decision and then make a note in this case. But it should be taken as one single case, not as two identical cases. And my later proposal would be maybe we should have a certain provision in the law on personal income tax. What are those taxpayers? For instance, when we have taxpayers as a couple, as spouses, it should be defined in the law. We should have clarity on this. And to conclude my speech, my final illustration, a case from the Supreme Administrative Court of Lithuania, when we have referred to the European Court of Justice regarding VAT. I remember that we could not find an answer while the answer was in the comments, in the commentary on the law of value-added tax, and let's say when economic activities are implemented by two entities, so how VAT should be applied. The Court of Justice has interpreted that we need to define who is the taxable person. Of course, the Court of Justice has dealt with based on major definitions which are included into the VAT directive and not in some commentaries or explanatory notes. So sometimes in tax cases, we fail to find answers in the, let's say, VAT law or on law on tax administration, but we find an answer in the commentary to the law or in the interpretation of the tax administrator. So probably that is something not completely well regulated, and we shouldn't have this, that you only find an answer not in the law. So that would be my brief presentation. Thank you very much to our speaker. Without any delay, I would like to invite Professor Dr. Gediminas Užubalis, who is the chairperson of the Regional Administrative Court. His presentation is about the role of court in examining tax disputes. And you also have a right to coffee, so please do not forget about our right to coffee, because I'm the person who is standing between you and coffee. So I have this responsibility in mind, and I will be accountable well for this.
So the role of the court. We started talking from the fact that the key organizes the Tax Disputes Commission, and thank you very much for this well-organized event. But firstly, thank you for well investigated and well-presented cases. And we'll talk about the role of the courts, and now we are focusing on pre-trial institutions, tax administration. But the question is, what is the value of the court in the process? So I'm going to try and talk about it, and we'll start talking about trends and the situation at hand. Maybe my first topic will be the role of tax disputes in our court and what part of our activity it comprises, and then we'll talk about what the court could qualitatively contribute to the value, and then we'll talk about activity and activism of the court and how this could manifest in tax disputes. So the trend is that probably the percentage of tax disputes is decreasing in 2019 if we look at the latest peaceful years, because then we had the pandemic, and then we had the migration crisis, and we had approximately 200 tax disputes, but it's with tax administrator. Our system does not allow to pick out very precisely, but it's about 200, and the percentage is dropping probably because the number of administrative cases is rising, especially the peak was in 23-24 when the basis increased to 23,000 to 24,000 at court. Therefore, the percentage at court remain very small, and the percentages are more than 1%. So of course, they are very specific and very important, and then we can ask a question, what court can speak on the topic? So we have the administrator, the commission, the taxpayer, and maybe it's not always a large taxpayer or economically very large, but they can sometimes hire experts and attorneys at law, so we can have a big team of experts, and what court can contribute. in this situation. And I should probably acknowledge that the court is not the largest expert in tax in all cases. However, it does have certain tools, instruments, and possibilities on how they can hear a dispute fairly. So I'll probably talk about benefits and advantages of the court and how the court can help. So, of course, a lot is done by the administrator, pretrial investigation, and attorneys in law who work very diligently in trying to find the matter of the case. And the situation when they arrive to us, we have this a lot purified information, and sometimes when we look through the audit reports, we can see that there is no more dispute, and out of 20 episodes we have 5 to 7, and that becomes much easier for the court to go deeper into certain situations where a dispute already has its limits, and after they've traveled through several instances or institutions to the court. And another advantage of the court is that although the court is not an expert, it does have skills and experience on how to apply general legal principles and horizontal experiences from other cases and public administration situations, or a wider attitude and look from the point of view of protecting citizens' rights. And probably certain disputes have been enriched through that point of view. And for example, declaration stability doctrine was established where the Supreme Administrative Court applied legal analogy, which is not very frequent, and other cases, for example, privacy protection in the case the administrator used the criminal intelligence to calculate the tax, to levy the tax, and they do not frequently face such situations, but the law looked at how criminal intelligence can be used in public law and decided that such intelligence in tax calculation is not proportional measure. So the advantages of the court, which arise from the fact that we're not the largest expert, that we can use the general law principles, legal principles, a big mass of environmental so-called cases with a fixed tariff or fixed rate was applied. And the law was very inflexible because it was only 10 times sanction calculated 10 times more than the levy tax. So from 0 to 500%, but using the constitutional penalizing principles, the court individualized the situation. Another part of the topic is activity of the court. It's quite popular activism. I'm not going to go deep into it. It's a multifaceted concept and can be viewed critically and non-critically. And activity in a narrower understanding, we can look at it through describing and explaining legal norms, and criticism comes from activism, that the law crosses the boundary of formal regulation and is trying to find something that is not written in the law, or sometimes looks at the situation from too wide of a perspective. And the role of the court is important, and the court can and must question the written law, and for that we have instruments used by the administrative court. Firstly, addressing the constitutional court. Secondly, addressing supranational courts, and the area of taxes very closely related with European courts, and administrative courts are important not only as national but as European courts as well, and only with their active involvement and collaboration with the European Union courts we can ensure the EU law implementation. And another specific area is the micro level, identifying circumstances and facts where a court must be proactive. And in formal law, we have quite a lot of obligations, what areas of activities there are. So being active in establishing evidence ex officio comes from the obligation and the necessity to protect the public interest. What is the public interest is a question we know very well, how wide of a concept that is. But obviously the activity of the court is required to determine the objective truth, separated from the civil court. But the public interest does not manifest from the tax administrator or fiscal or budget support, but public interest is also important as legal justice. So we cannot only understand it as focused on the support of the tax administrator. And we can have different attitudes in European systems, legal systems. They are similar, but what could be the role of the court? And it depends on whether it takes over the public administrator's function, or is it only a revisioner in a narrower sense, looks at the legality of the decision. And in Lithuania, we have the doctrine that firstly, we look at the legality of the decision, and the court does not rehear the case. It does not stand in the place of the administrator. It does not take decisions for it. There is a very strict, rather strict separation, and the legal power does not intervene in the tax administrator's functions. So from our case law, we can find different formulations, and I provided several of them on the slide, that providing evidence and proving starts with the administrative institution, which needs to collect evidence and substantiate it, and then the court revisions and revisits it to see whether that was done correctly. So on the other hand, the role is active because we need to ensure the operativeness of all this process, and the case can only be returned back to a lower court of instance or a lower institution in certain cases, but our main objective is to resolve the dispute, and our Supreme Court has spoken about that it's not a quasi-appeals function, but looks at the case in essence and substance, and the court must resolve the issue or speak out on the breached law. So we have two doctrines, so to speak, that one says that we're more limited, which have to revise the decision, and another which requires to be more active and to look at the case in regards to the law, and which requires to firstly identify whether all the circumstances have been identified by the tax administrator and substantiated it, and if not fully done, in that case, whether those gaps can be eliminated during the court hearing, or should the decision be annulled and the case should be started from the beginning. So one of the main criteria is that the obligation to motivate stays with the national tax administrator. It must remain active. They always have the ball or the hot potato in their hands, and they always have to collect evidence and substantiate their decisions. And we can also use the doctrine from the public administration on the motivation, obligation to motivate. And if out of those motives, it's clear what was the basis to take the decision, within these limits, the court, within the formulated decision, the court should act. Of course, if there is insufficient circumstances, evidence, the court can collect the required evidence, but they should not diverge very far from the initial decision, so it should not surprise the parties, especially the taxpayer, that all of a sudden we've collected more evidence, and look at that, we have a situation that is even worse than you thought. So I've said pretty much everything, so we can summarize. The administrative court is important as an arbitrary institution, as an arbitrator, which examines tax disputes, ensures the right to judicial protection, and complementing specialized institutions, and uses general law principles. And talking about activity, we need to ensure the balance, and the court must remain impartial, even if it's proactive and aims to make sure that the case is heard in substance. Thank you very much. Thank you very much. And 11:05 we'll start the second part, so please enjoy your coffee and come back soon.
Sveiki.
Welcome back after the coffee break. Thank you very much for being considerate of our time. So we will continue without any delay. In the first session, we focused on tax disputes in Ireland, and in the second session, we will focus on tax disputes in Lithuania. And may I invite a member of the Tax Disputes Commission, Gvida Ivanauskienė. Good morning. Welcome to everyone. I would like to congratulate you all on a very quick coffee break, and then we'll come back to our discussions. I am a member of the Tax Disputes Commission. I will be speaking on behalf of the Commission today, and my topic is the anatomy of tax dispute, parallels between regulation and interpretation. I promise there will be some anatomy involved, but I'll discuss the tax dispute concept and definition more than the anatomic aspects. So my presentation will be made of two parts. The one will focus more on the tax dispute itself, and the second one will focus on the process itself. As well, the main goal of the Tax Dispute Commission is to analyze objectively the complained by the tax dispute applicant, and to make it as fast as possible, as effectively as possible. So we have to ensure the implementation of the rights of the taxpayers. So they have to understand and have a clear understanding of what a tax dispute is, and when and where he may appeal. What we see in our practice that taxpayers do not always understand what a tax dispute and where he can appeal to our commission. And this is where we have a collision between the understanding of a taxpayer and the provisions of the law. And we are looking for the ways to bring more clarity in this. So since I promised a little bit of anatomy, so my promise is here on the third slide. So I will make a comparison between the anatomy of the hand and tax dispute, and maybe explain you how a taxpayer understands a taxpayer. You know, a hand is a hand, like a tax dispute is a tax dispute for a taxpayer, and he sees that there is a dispute when a taxpayer has been calculated more taxes than he expected, or some new taxes are added, or that he is not subject to certain exemptions. So when he is refused to refuse a contract for a tax agreement, and so this concept is pretty simple. The law on tax administration or medical books have a different approach to a hand. Hand is made of many different bones, of 12 to be specific. And if we put them in the wrong way or in the wrong sequence, the question comes, will a tax dispute be a tax dispute, and will the taxpayer be able to enjoy his right to defense? So this will be the areas that I will try to analyze in my presentation. So what is a tax dispute? In the law on tax administration, it defines it as the right to appeal any or all tax administrators' actions or inactions according to Article 140 of the mentioned law, or any, like it is defined in Article 142 of the same law. And what is the difference between any and all actions? Maybe the legislator can explain this difference more, but that is a rather broad concept. So everything or anything can be appealed, and this is a beginning of the long road to the entire understanding. A tax may be a tax or non-tax dispute, let's say redemption of certain taxes can also be seen as a non-tax dispute, and he may be referred to a separate institution for that. So this is kind of a bureaucratic burden to taxpayer, which taxpayers try to avoid, and then they rather do not appeal against at all. So what is a tax dispute? The Part 2 of Article 22 has a definition. First of all, he has to debate this with the tax inspectorate, with the tax administrator, and this tax administrator has to prepare certain procedural documents. This decision should also include newly calculated tax, or a tax administrator, let's say, makes a decision or on refusal to return excessively paid taxes. So tax dispute is considered to be a tax dispute when the let's say, different actions are appealed, let's say, like individual tax administrators' interpretation or recovery actions. And who makes the final decision in calculating the taxes, territorial, let's say, taxes? Was it the decision made by territorial or central tax administrator? In the current day, we have an interesting situation that the procedure of appeals depends on whether the central or regional tax administrator has made a decision in one or the other case. And we have similar division in the customs department or environmental inspectorate. Only having assessed that the decision has been made by the central tax administrator or by the territorial or regional tax administrator, and this decision has been approved by the central tax administrator, we can say that this is a tax dispute which has to be dealt by the Tax Disputes Commission. I also have drawn an arrow below on the bottom that based on the procedure, there are a number of factors to be taken into account, various requirements such as the maturity, the deadline for appeals, and many other procedural requirements. Does taxpayer really understand what a tax dispute is and whether he presents his complaints in the right manner? I have to say that no. We have a big variety of various non-tax disputes, let's say, when they ask for various individual tax administrators interpretation when something he is not allowed to do. And let's say this year we had 10 appeals like this. Taxpayers also appeal to our institutions regarding the statistics regarding the incorrectly applied tax-exempt amount, other actions of the tax administrators, or interpretation from institutions or companies other than the tax administrator. And like I mentioned, other actions of the tax administrator, let's say a refusal to conclude a tax loan agreement or unapproved certificate of tax residence, and etc. What I wanted to add, according to the data of Administrative Disputes Commission, and according to the data they have presented, 37% of claims regarding tax cases fall within the Administrative Disputes Commission by accident. So this means that taxpayers don't really understand well what a tax dispute is. We try to see and to look for a case law abroad in other EU countries, and we try to see what are the definitions of the tax dispute. But we did not really find a strict definition like we have in our legislation. We really could not find it. So there are more like general definitions and understanding about tax disputes, that this is something unlawful that has been done by a tax administrator, or some disagreement with the tax administrator's actions, but we could not really find any strict definition. I will now move on to a very relevant topic that has been touched upon by the Judge Veslava. Article 104 of Law on Tax Administration and the problematic that it raises. That is a highly relevant article for us. We have a number of disputes suspended because of this provision, because we are still trying to sort out whether it is a tax or non-tax dispute. Last year, we received several complaints from taxpayers, and they were like late complaints. They came from the Administrative Disputes Commission, and they said that it was a tax dispute. We have renewed the deadline for filing an appeal, but these decisions were appealed against by the tax administrator, and their arguments were that their dispute resolution procedure is based on the law of administrative proceedings, and that is not the competence of the Tax Dispute Commission. And these disputes are now being examined in the courts. One of those I know is already at the Supreme Administrative Court of Lithuania. So we're looking for the resolution and final decision whether it is a tax or non-tax dispute. And you may see in those small letters that the decisions that are still open, and they are still open in every institution which deals with disputes. The administrative Dispute Commission has different decisions, both that it's non-tax and tax decision. The Regional Administrative Court has also expressed their position on this, and the position is not unanimous. This is why we are looking for the position of the Supreme Administrative Court of Lithuania, because now we have 8 disputes suspended, or maybe even more. And we are looking forward for the decision in this to know how to proceed. And just like tax administrator says, according to Article 104 of the law on tax administration, it is only a proposal to pay. And they do not accept any other procedural documents. They do not make the final decision. But this proposal to pay, how we see it, so this proposal usually ends with a question, what happens if I don't pay? And the answer is usually that if you fail to pay, if you don't pay the debt in 14 calendar days as of the receipt of the notification, tax administrator will recover this amount in legal manner. So it's a kind of a voluntarily encouragement to pay, a reminder to pay, but at the same time it is also a request. So in the position of the Tax Dispute Commission is that it is a tax dispute, but the court it sees it differently. So what we are aiming for, first of all, we are focusing on the taxpayer and their possibility to defend their rights easily and effectively. This is why we try to expand the scope of disputes classified as tax disputes. And I will speak about it a bit later. We also are trying to optimize the tax dispute resolution process so that there wouldn't be too many stages of a dispute, and so that it is not artificially extended. And taking a look to the future, we are thinking of how to make this dispute resolution process clearer, more consistent, and legally compliant. So first of all, our insights and proposals regarding the concept itself of the tax dispute. So the current dispute is like rather static, because we have a growing number in some types of disputes and a lower number in some other kinds of disputes. So we see a space for improvement, and this definition of tax dispute has to be expanded. Taking into account the provisions of the law, there's no possibility to reduce profits in incurred losses in the future. As far as I have discussed on this matter with the tax administrator, they have this common understanding that this is a tax dispute, even though there's no obligation for the given period. But we still have this court case law of the Supreme Administrative Court, where a dispute on losses was not attributed to tax disputes. Further, binding decisions when a taxpayer approached the tax administrator in advance and provided a likely assessment of a future transaction, and it was important for him to hear the tax administrator's position, especially when we have large-scale reorganization happening. And tax administrator can make a positive or negative decision. They may approve or disapprove a likely future transaction. And such a disapproval is really significant for a taxpayer because it is directly linked to the calculation of taxes, to filing of the refund and payment of taxes. So these all items should be included into tax disputes. Decisions on binding tariff and origin of information in custom administration. Custom decisions on classification directly determine the customs duties and other taxes levied on goods. But depending on this decision, well, this decision determines what customs duties and what other taxes are levied on goods. So we believe that such decisions could be disputed, and they should be disputed as tax disputes. And there are also other categories that could be included into the definition of a tax dispute, such as granting or refusal of tax status. Let's say if the person is deleted from the VAT payers list, so that has an impact on his tax-paying obligations and granting or refusing tax loans. So I have provided several alternatives for those concepts of tax dispute. So they both cover disputes not only concerning the calculation, declaration, refund of tax and or other related amounts. So this means the entire broad scope of administrative functions and their enforcement. When it comes to broader enforcement of tax obligations, we would eliminate such a case when a taxpayer has to appeal to two different institutions, and they would be able to resolve their tax disputes at one institution. And then if we had this broader definition of tax dispute, the entire procedure would be simpler and clearer. Taking a look to the future, we see taxes which were not included into the concept of tax disputes, but they should be there. One of those is environmental pollution taxes. We had made the decisions on environmental pollution taxes, but we still have the remaining fee for state natural resources. And these fees yet are not subject to tax disputes. They always have to be examined by court, but we believe that the same procedure should apply and they should be subject to appeals of the Tax Dispute Commission. We also want the tax dispute process to be clearer, and we always ask whether the tax administrator, as the central institution, is effective in the dispute resolution stage, because taxpayers often ask us, why should I go to tax administrator? Because they don't care whether the decision was made by a regional or a central tax administrator, because you have to appeal the same decision to the tax administrator itself. So we are not really saying that such a stage should not exist, but there should be some kind of internal procedure, reviews, quality insurance, equal case law, but that is a matter of the internal management of the institution. So what we want, because I only have a few minutes left, I will be brief. So taking a look to the future, we think that the Tax Disputes Commission should have a separate individual status, because now we are included, we are a part of the law on tax administration, but we rather implement the right to defense. So there are two different functions, two different purposes, and we are in between the Article 140, 146. And we are only mentioned occasionally, and serious, important procedural questions are not defined and resolved in the law, as well as the cases when the Commission has to stay behind. So we are really short, and our role is not clearly regulated and defined. So we are really looking, hopefully, at the law on procedure of the examination of pretrial administrative disputes in Lithuania. I know that this law has been revised for even 14 times and amended a number of times. So this means that it can be amended and revised in future. So we are looking forward for these, and we are looking for a separate law on our activities. We also want to extend the deadline for appeals, because the term of 20 days is too short. The tax administrator has a long time to make their decisions, that is 60 days, while the taxpayer has to deal with and implement the decisions within 20 days. So you want to extend it at least up to 1 month. And we want to extend the decision making to another 30 days, so going from 60 days to 3 months. So all the deadlines that we have defined in days, we suggest to harmonize them, and everything's defined in the other law by month. So we suggest harmonizing it and having it all those terms and deadlines indicated in months. So filing a complaint is also subject to 30 days, so we propose to change it for 1 month. And we have a number of proposals, and implementation of those could be defined in one single law. And now we can already make references to the European Court of Justice regarding certain preliminary positions. We also would like to make references to the Lithuanian Supreme Administrative Court, asking for interpretation whether certain laws or provisions of the laws are in line with the procedure. And since I am in a hurry, I have heard during one of the welcome addresses, I did not really have time to use the services of the Tax Dispute Commission, but if you have such an occasion, make use of appealing the Tax Dispute Commission, because they make the decisions fast. There are no taxes applicable to the process. The process is very simple, and we ensure quality, and we try to make a tax dispute not a luxury, and that the right to defend your rights wouldn't be a luxury. So don't pay taxes more than you owe, more than you have to. And this is what is our purpose. Thank you.
Ačiū Gvidai.
Thank you very much for the presentation. And while we're waiting for the presenters to change, I should say that to most of your suggestions, we should probably agree. And we'll finalize this part of the conference with Eglė Bilevičiūtė, Professor Doctor from Mykolas Romeris University, Prospects for the Developments of Pretrial Administrative Dispute Resolution in Lithuania and Problematic Aspects. So some things have already been said. I'm going to try to avoid repeating what we've already heard, and I do agree with all the ideas that have been already explained. I'll talk about this lack of clarity, and talking in general, not only about tax disputes, but disputes in general. I would like to invite you to look at this phenomenon from a wider perspective. We just had our administrative court's 25 years anniversary, and we have this mature justice system, and we have 35, I'm sorry. We have different commissions, quasi-legal institutions that are under different subjects, different bodies. We've already heard about tax disputes, but also we have Lithuanian Administrative Dispute Commissions. We also have similar Chief Official Ethics Commission, Central Electoral Commission, and we have central departments, not only state or national tax administration, that have to hear different disputes, but also ombudsperson type institutions. And I'll talk about these two, Lithuanian Administrative Dispute Commission and Tax Dispute Commission, which were established differently from other institutions that I mentioned. These ones are especially for dispute resolutions. And other institutions look at different situations on administrative cases. They are more multifunctional and quasi-legal, and disputes are only a part of their function. And these two particular institutions, Lithuanian Administrative Disputes Commission and Tax Disputes Commission, they have been established especially for disputes. The Lithuanian Administrative Disputes Commission is larger. It has 27 members, and it has some branches, territorial branches, similar to regional administrative courts structure. And Tax Disputes Commission has only 5 members. And for the entire Lithuania, especially looking at the perspectives and trends that we've heard from the previous speaker, possibly this number is not sufficient. However, if the reforms are approved, and if the parliament members will hear us, and I hope that this is going to happen and they will attend to our needs and implement the required changes. And today I talk as a researcher, and I cannot say that what I'm going to introduce, that all the members of the Commission agree to what I'm going to say. But what's important is that we have a system that has been developed. And according to the statistics, and according to the decisions taken by Tax Disputes Commission and Lithuanian Administrative Dispute Commission, so only 11 and 13 of their decisions are appealed against, and a very small percentage of them are reversed by the court. I would say that these institutions are very effective. They are very useful. And as my colleague said, dispute resolution is fast, effective, and the Administrative Dispute Commission has even shorter deadlines, a month, month and a half, and you can have the final decision. You can see that people choose these quasi-legal institutions as their path to resolution, and they are equated to tribunals, and as disputes commissions, appeals to ESTT, or European Court of Justice also indicates that. There are some statistics that I wanted to demonstrate that complaints received by Lithuanian Administrative Disputes Commission, they have only one type of disputes. So both commissions, previously they never heard administrative disputes, and if we have 40 according to the classification, the Administrative Commission can only hear half of them, and Tax Disputes Commission only tax disputes that are defined very narrowly. So when there is a possibility to hear disputes on rights, for example, of the disabled, the number of disputes increased at the Lithuanian Administrative Disputes Commission. And this is the mission of the institution, to receive more disputes from the public. So these are decisions made by Lithuanian Administrative Disputes Commission. I shouldn't say that no reforms have been taken since 2018, since when the Administrative Disputes Commission has been enlarged with territorial branches. Quite a lot has been done in non-legal mediation, and also certain provisions of laws have been revisited. So the functions have been enlarged for both commissions, Administrative Disputes and Tax Disputes Commission. And for example, pollution cases have been attributed to Administrative Dispute Commission, but they're non-complex, more episodic. And in my understanding, it shouldn't be so episodic. The revision should be more complex, so looked at as one body. And tax administration law, as it's been mentioned, should be only applying to tax administration, and the Tax Disputes Commission should have its own law. Because we heard that there is a very clear division of power, and public administration subjects have their functions, and quasi-legal institutions have their own functions, and courts have their own, and we should not mix and match. And the question is whether the Central Tax Administration, SODRA, and other public administration subjects that hear certain administrative dispute should actually be doing so. Yes, of course, we have the administrative procedure, and it's established, and people, individuals, if they want, they can address the subject itself in relation to the dispute. But the question is whether they should lose the right to use the Administrative Disputes Commission possibility, because the process is not as formalized, and it has no tax applicable to hearing the case. So the question is whether the taxpayer or the citizen should be deprived of such a possibility. Another thing which is important is that the process, and one of the advantages, and the courts also said so, that they can ensure distance hearing. So these are quasi-e cases, and all processes are digitalized, and they are trying to become paperless. So I would see the following development directions. Both of the commissions should be connected to Liteco system. They are not, of course, courts, but that would make it easier for applicants to submit their applications. But if there's no qualified signature submitted on the electronic document, then the application can be not accepted. But that's a sort of a mockery of a taxpayer. Because a tax administrator can do something like that, but not a taxpayer. And it shouldn't be so. And these information world-related issues, because Liteco has very wide functions and voice-recorded files and document submission, it's completely different to what we had at the commissions for digitalizing and systematizing documents. And tax administrator, according to the regulation, has to discuss, and the Tax Disputes Commission as well as the Administrative Dispute Commission should apply non- or out-of-court mediation. And if they don't want to take it, it's their choice, but now there's no such a possibility. So I'm not going to repeat what's been said, but I believe that the Tax Disputes Commission should be that type of institution. And of course, when we talk about new competences, it sounds like give us more work, which is not so. We do have sufficient work, and our indicators show that we are effective and beneficial, and we hear a lot of cases. And the widening of competences is more about the strengthening the institutions, making them more accessible to people. For example, for service-related disputes, which has been suggested 5 years ago. And Administrative Disputes Commission, for example, cannot accept cases on litigation expenses. And the 20th article, without the obligatory hearing. So all of these would give results, and I believe that the Administrative Disputes Commission, with some exceptions, should attend to different types of disputes. And Tax Disputes Commission, I do agree completely, accept all disputes related to taxes. The previous presentation reminded me of a situation several years ago when we faced a number of complaints that arrived to us in relation to state tax inspectorate's documents or requests to clarify the tax returns, and they ended up with Tax Disputes Commission, but there was not yet a dispute. There was only a request, and imperatively requested to amend the return. But people addressed the commission because it was a question on commercial property taxes calculated or related to commercial property. And the question was whether the Disputes Commission can actually deal with such applications and such complaints. And I remember that applicants were very angry that they needed to go through several steps, other institutions. And the questions have already been asked about calculations and levying, possible levying of the test. And when we talk about a single or one service approach to all services, but not tax services. So what's related to taxes before taxes are calculated or levied or exacted, it's clear that it also should come to us. But the applicants, when they come to Administrative Dispute Commission, they expect for a tax issue to be resolved. And we cannot do that. And they get this answer in a month or in a month and a half. They receive this decision, which says that is not helpful. So this is an erroneous situation, and such unclarity should be resolved. So I guess these are the key issues. I already spoke about legal regulation, about and I've already spoke about it. And thank you very much. If you have any question, I'll be happy to answer.
Thank you. According to our agenda, we have 20 minutes for discussion. But I think that we will not have an opportunity for everyone to speak at that discussion. So I will try to be the devil's lawyer, or me in myself, and to ask a few provoking questions. We heard many answers, maybe, but well, in tax disputes were addressed in Lithuania, probably we would all agree we have a good backbone of the system. The question is the evolution and growth and empowerment of the system that we have created over the past decade. Judging by the statistics of the Tax Disputes Commission, we see certain trends that, let's say, in the past we had 300 disputes. Let's say last year we had 200, while 10 years ago we had 100 million complaints. So the question is, maybe we have a very professional tax administrator, or maybe we have very good tax consultants, or maybe laws are very clear and they have improved so significantly, or maybe there are certain gaps and gaps in faith of taxpayers in the system, So maybe people who deal with tax disputes, how they see this other side and what are those trends. I will start, if I may. Well, indeed, I would like to say that when it comes to tax disputes, they are rather specific, because in these kind of disputes, we are not looking for the guilty party or for someone to blame, but we are trying to resolve and to see how to fairly tax or not to tax someone. And tax disputes help us see certain gray areas in the conflicts, certain gaps of laws, and by doing so, laws and commentaries to the laws are amended and revised, and the truth is born in these disputes. So yeah, certainly some types of disputes are getting some numbers of those types of disputes are getting lower, and we have, of course, some disputes where we see the point in conflicting, discussing this. We are working towards this. This is why we are talking here. We're trying to improve the system. We are trying to show that that is necessary. Sometimes we are limited by the provisions of the law. Gediminas, you had some statistics from the court. the percentage is going down, but the number of other cases is going up, I guess. So my question would be, how do we find the right balance? Everyone's rights is important, but are all cases equal, or are all cases the same? When in tax disputes, it is pretty usual, especially when we speak about tax disputes which come from pre-trial stage, already like prepared dispute. In the court, such a dispute is resolved in 2 or more sittings. Well, I think this should be the case. Isn't this an advantage on one side, but on the other side, maybe it's a drawback when this dispute is, well, nicely packed, well prepared. But if there is a mistake in the first step made, isn't it the case that you have to correct that mistake in the last stage? Yes, you usually correct the mistakes in the last stage. This is what happens. And usually this happens in courts. As for the trend itself, I think we have different kinds of disputes and the increase in different kinds of disputes, and it has increased rather drastically. But when it comes to tax dispute statistics, it remains pretty stable. So just like we started, the court, even if the scope is more narrow, but the possibilities of the court is bigger, they can dive deeper into those disputes. And if we define that there was a mistake, then we have to admit it. And the court is not the institution which should paper over the cracks or the administration gaps. The court should be able to resolve the dispute if it is possible. We should not come to a dead-end situation or to a critical situation when there were certain aspects were missing, certain circumstances were not included, and then the entire dispute diverts to some different direction. So we have to balance it up. And I believe that we can resolve a dispute in depth during one sitting. And if the case is well prepared, I believe it should be the case. You know, if there are 2 other institutions who dealt with the dispute before, so I think, yes, it does not need that much time. Go ahead. I can be an even bigger devil's advocate, and I could suggest a tax dispute commission of how they can ensure a higher rate of disputes that would be dealt by the commission, and not for the sake of increase in a number, but for the sake of taxpayers' rights defense through the commission, through the tax dispute commission. So let us think why taxpayers don't go to the tax dispute commission. Of course, I'm happy that over the past decade, tax consultants become so much more professional, and they help our taxpayers much better. And they are more collaborative with the tax administrator, but still certain uncertainty remains, and tax administrator would like to see a certain separate opinion from the tax dispute commission in certain cases. It's not necessarily that we should have an agreement which is convenient for the taxpayer, but maybe having a position in, let's say, in some unclear situations from the tax dispute commission, and what limits the taxpayer from appealing the commission. That is the default interest rate which limits. Because if you lose, you will feel this painfully, or on your pocket. So while the tax dispute is examined, so that both tax administrator would try to resolve the case the dispute as soon as possible. The Tax Dispute Commission should not examine it for 3 months, but should do it as soon as possible. And then, let's say, a certain number of days would be exempt of the default interest. So giving all this package to all package of amendments that you have proposed, just imagine what instruments should we have in legal sense so that we can intensify, this process of dispute resolution. Especially in the cases when there is a lack of legal certainty, so the taxpayer it should be within the interest of the taxpayer to go to the Tax Dispute Commission. I'm only speaking from my practice of how we can make our laws more specific and give certain benefits that way to the taxpayers. We have to defend public interest, not only the budgetary revenue, but also the interest of our society, so that taxpayers find the laws clearer. I see that we should strengthen this area. Thank you for your position. Going back to the beginning of our conference, the dean of the law faculty and other speakers also raised that question, whether a dispute is a conflict, whether it is some disturbance of social relations, or it is something which works for the better, leads us to better regulation, better resolution of disputes, or is it some kind of destruction? So we should not punish the taxpayer because he is trying to appeal or dispute certain things. Well, but the question that I get by listening to all this is who is the weak party in the tax dispute, or who is the strong party in the tax dispute, and who feels how, whether the state is the weak party because somebody is threatening its revenue, or it is a strong party because it defines all the rules, it implements all the rules, and in the eyes of a taxpayer, people delegated by the state make the decisions. Is there anyone to comment on this? Well, to be more specific, there is this requirement of proving. We have the principle of proportionality, and that the case is only initiated when the complaint is received. So there are certain steps from the side of tax administrator also has to be. But we all know. Well, we cannot maybe refer to as the weak party someone who appeals the administrative court, let's say in a tax case. But the question, well, it is rather a matter of proof. We all know that public administration entities, they have to argument their decisions, and this is where the burden of proof comes in. And the administrative court should get a well-prepared case, and when it comes to tax dispute commission, it is prepared well in advance. What we don't really emphasize in administrative cases, but it has to be emphasized in all administrative cases, that when you have and when you file a complaint, the applicant shouldn't be proposed to file the proof. Should be clear that every public administration entity should file a complete case to the court, and that would make the background for the administrative case. So it has certain obligations. When it comes to administrative court and entities who appeal to the administrative court, we cannot have applied the same requirements to taxpayers, to applicants, like we do to public administration entities. So that is one aspect of general nature. Another aspect, that this burden of proof in tax cases strongly relies on the nature of tax dispute, or the nature of the case. And from the courts of the Court of Justice, we see when it comes to VAT, the Court of Justice always clearly states that tax administrator has to prove, if they define that, let's say, certain rights are limited, let's say the cases of VAT evasion or fraud are established. So if the tax administrator defines this, so they have to provide arguments to prove this. So this is what we clearly see from the Court of Justice case law. And if, let's say, the taxpayer is asking for certain exemptions, or if he wants to argument his position, then we are asking for the taxpayer to provide certain documents to prove that. So it all depends on the nature of this tax case. But then we all have to be very cautious about this, both tax administrators, both institutions who deal with those disputes, and the court as well. We cannot ask to provide the same arguments in all institutions. First of all, there are general requirements, but then we also have to take into account the cases, specific cases that we are examining. And then this burden of proof is equally distributed. I see the time, and I know that lunch break is approaching. I would like to thank all the speakers. And before leaving for lunch, I have a rhetorical question to everyone. Which is worse? Ungroundedly approved or ungroundedly dismissed decision of the tax administrator? Thank you. Thank you, moderator, for great moderation. Now we have roughly 45 minutes for our lunch. So we'll have some time to have some treats, some snacks, to be able to continue our work in the afternoon, where we will focus on specific tax-related situations, tax-related problems. Thank you very much for attending this first part of our conference. Let us enjoy our lunch. Welcome back after lunch. I hope you have exchanged some good ideas, made some contacts, discussed not only tax. Let us move on now to the second session, where we will focus more on various tax dilemmas, collisions between the branches of law, and tax problems which emerge both in practice and in tax disputes. And the second session, will be moderated by a true practitioner, I would say, an active representative or active party in tax disputes, representing the parties in disputes. A lecturer at Vilnius University, Dr. Povilas Gruodis, who is also attorney at law, practicing attorney at law. Povilas Gruodis. Thank you, Vilma, for this introduction. Well, taking a look at the agenda of today's conference and its division, I have a general observation that the first session rather defined fundamental philosophical topics, defining what a tax dispute is, what definition or concept it should be limited to, while the second session is like a combat session, a fighting session. I believe this will be a heated debate, because it's not what a tax dispute is, but all the topics take us directly to the dispute itself and explaining why those tax disputes arise at all. So these are thought-provoking topics that I see in the second session. The first presentation is always relevant, because in our university I see it is always among the topics for master thesis, and students usually choose this topic, even though this topic has been addressed for 20 or so years, but that is always relevant and important topic. And this is something we see from the case law of Court of Justice, European Court of Justice, because it keeps revolving year after year. So I guess this shows the importance of this topic, and we have a topic about 0% VAT rate. And this topic will be presented by the representative of the tax administrator, who knows all the nuances related to the application of the 0% VAT rate. So that is Dr. Martinas Andriaitis. Good afternoon. Thank you for this introduction. My topic is the application of 0% VAT. I will start the second combat session, focusing on in a specific aspects. So I hope that you will not get too sleepy after lunch. I will try to wake you up from sleep, and I will review this topic of 0% VAT rate. So since our conference is both scientific and practical, so I will try to provoke you by contrasting the recent Lithuanian Administrative Court case law in this 0 VAT rate, and the 0 VAT when you supply goods to another EU member state. I will also discuss certain rules of the regulation, the EU regulation, and address certain problematic issues of how we should see the good faith of taxpayer in some situations. So let us start with the case law of a Lithuanian Supreme Administrative Court. And when I am the representative of a tax administrator, so I can tell one part of the story. If I were the representative of business, I could tell a different story. So that is a classical discussion. So the truth lies somewhere in the middle, as usual. So when it comes to the case law of the Lithuanian Supreme Administrative Court, I would like to address the principle itself. I will not speak about any particular case. So I will simply speak about the cases when when you supply goods to another EU member state and it is subject to 0% VAT. So the focus is here that the buyer is in charge for transfer of goods, and the right to dispose of the goods was transferred to purchasers at the seller's warehouse, with the goods being loaded onto means of transport provided by the purchaser themselves, and the third important aspect, that the goods were not actually transported, and that is the key requirement for 0% VAT to be applicable. So just like often we have in case a tax administrator has a foreign state, it's like be it Poland or Estonia, and they have information that the goods were not physically transported, so there is no dispute physically. All facts have been established. But the practice over the past several years, and the tax administrator held the position that when it is stated that the goods were not transported outside of Lithuanian territory, those kinds of supply were subject to standard VAT rate, and then the obligation is to pay the VAT to the seller. And this was applicable despite who was the buyer or who was the seller. And fairness was not taken into account. We all know that the consumption tax means that goods were not transported from Lithuania and the goods remained in Lithuania, so 0% VAT was not applicable. Lithuanian Supreme Administrative Court explained in its ruling that those three previously mentioned conditions were established, and the buyer was responsible for the transfer of goods. And the court explained that until now, in situations such as those described above, the tax administrator had essentially taken the position that, having established that the goods in dispute were not exported from the territory of Lithuania, the supplies in dispute should have been taxed at the standard VAT rate. The obligation to pay this tax rates rests with the selling company, regardless of its good faith and who transported the goods. And the court also specified that if the seller himself is responsible for transportation of those goods, then good faith has not to be assessed, does not have to be assessed. And if the fact of transportation of goods is denied, so that good faith of the seller is no longer relevant in terms of VAT. So I believe that this explanation of the court is sufficient. So that sufficient to tell that 0 VAT is not applicable in this case. I would like to provoke some thought, because some of you may say that the good faith need to be assessed, while the others may say that it should not be assessed. So after this ruling of the court said that in the cases when the Lithuanian company or the seller, it had to pay to the state budget VAT for the disputed supplies. And the tax administrator had to assess the seller's good faith, whether it knew or could have known about the purchase's VAT fraud. In the past, we had this condition that the buyer had to be an entity of another EU member state, and those goods had to be transferred to another EU member state. And starting with 2024, stricter requirements were introduced. That the properly filled in VAT form had to be filed to the tax administrator. Until 2011, the buyer was the VAT payer of another EU country. And starting with January 1st, 2020, according to EU regulations, certain requirements were established. And other proof that had to be provided. We all know about A and B paragraphs, and we often hear from lawyers that the regulation is not really in line with business practice. Sometimes these documents are not enough, or sometimes companies do not necessarily have those documents. There may be other documents involved, but the principle is that when we speak about proof of transportation of goods, there are different requirements for documents. And when, so that is paragraph A of the regulation, that is a CMR consignment note or airway bill, or it may come together with the insurance certificate and various other documents which prove the dispatch of goods and a written approval from the buyer about the type of goods and other likely proof. Why am I talking about all this? When seeing the positive law and the legislation, we may get the impression, based on the VAT law and the EU legislation, that we are making a decision upon the documents that have been provided by the buyer. To provoke you even further, the VAT law, when it comes to supply to another EU member state, a 0% VAT applies to goods supplied to a VAT taxpayer registered in another member state, who has provided the supplier of those goods with the VAT identification number signed to them by the other member states, and which are transported from the territory of the country to another member state, regardless of who transports the goods. To make it even more complicated, I have a question. What about the good faith if those goods are not transported to another EU member state, but it is transported to a third country, whether a zero VAT applies or not? So as far as we have discussed with our colleagues, there were certain disputes, but a final interpretation was not received. So the point is that Lithuanian Supreme Administrative Court has not made a decision in such a case yet. So if you want to apply 0% VAT for goods which have been transported outside of EU, so only in those cases it can be applicable. And finally, Article 50 of the law on VAT, when it comes to supply to other EU member states or the third countries, the VAT payer who has applied a VAT rate of 0% must have either the evidence that goods have left the territory of the country, and while other requirements continue. So going back to problematic questions, I would like to repeat. However, when deciding on the seller's obligation to pay VAT to the state budget for the disputed supplies, is the tax administrator really obliged to assess the seller's honesty or good faith if it is obvious that the goods have not been transported physically? And if it is obvious that goods have not been transported, so we have discussed this with business representatives. It's simply just an example. We are not imposing this practice. We're simply asking you to think about. We have heard, let's say, examples and who, let's say, entrepreneurs said, the buyers and sellers, okay, we are not taking into account if we knew or did not know, let's say, but we don't really understand this. So we do it in a simpler manner. We simply, if the goods are transported, we agree with the buyer. They pay some kind of reimbursement or a deposit, 21%. Those goods leave the country, and then we return that deposit, and we do not freeze the assets of the company. And when those goods leave the country, we had a number of cases like this. So it's all clear, the buyer took out, transported the goods, and then we relieve that amount. So the principle is that there are some ways to implement it in practice. And let's say businessmen say that they don't really ask whether they knew or did not know about this obligation. So maybe the question is that we should not really think about this good faith or knowledge, especially that I found some of rulings of the European Court of Justice confirming this. And another question is, when it comes to the third parties, when there are customs procedures involved, and when we clearly see that the goods were not transported, there are no documents to prove that the goods were transported, and it's all clear. Do we also have to assess sellers' good faith in these cases as well? So in my understanding, we should not go into these concepts. And of course, I do not mean specific cases of fraud, but the general idea is that if the buyer really transports the goods, and we can see this, so we should not take the seller's goodwill into account, but simply see whether the goods were transported or not, and then decide if zero VAT can be applicable. And to conclude my speech, we often hear the question about VAT for financial services. The law has not changed. The law has been simply amended by adding a provision from the EU legislation. So in brief, it would be like you have to assess it yourself. So there are certain criteria and conditions for this assessment. For some, it may seem as a financial service, and for some, it may seem not. So it's like, I think it falls within the same category as the assessment of the goodwill of the seller. And if that assessment, is sufficient or not, I think it is something for a further discussion, for a further debate. Should we develop this concept of assessment of good faith, or should we go rather into the law on VAT, and let us not play with these, assessment of good faith? Okay, we do not see the declaration, we do not see the statement, and the goods have not left the territory of Lithuania, so we apply a standard tariff of 21% of VAT. So these are my observations about zero VAT tariff. Thank you for your attention, and I wish you further interesting presentations.
Ačiū Martynui.
Thank you very much to Martynas. Martynas, I'm scared. But from what I heard from the content of the presentation, I think that it's not only me who is afraid, but also the sellers who were asked to provide an advance payment and for the goods to be transported across the border. So the question is, when we have such an attitude and there is no need for good faith, why do we need this zero VAT rate? Maybe we should function as business people. We should just ask for the VAT to be paid. We should maybe have this double taxation for a while, because this VAT directive is constructed in a way that someone can actually benefit from not being very fair. So the practice is that when we have the deposit 21%, the goods are transported and the buyer receives back the payment. So zero is applied, the buyer applies it. But we heard from business people who do that they don't need to think about being in good faith or not. So it's just a provocation that sometimes businesses find ways that we haven't thought about. Thank you, Martinos. Yeah, it's a hot presentation. We can probably continue our discussions during the allotted time. And we've just heard what business life is like. Next, we would like to invite attorney at law Indrė Čeponienė, who should probably bring us some more peace. Because when we hear about what happens in business, when they try to somehow protect themselves, Indrė is going to probably talk about a different method, which is more sophisticated, how business decides to get insured from such a point of view when nobody cares about good faith and everybody can be unfair. Indrė? Thank you very much. I'll probably continue this combat session with the question whether risk of tax disputes be managed, can it be managed, or maybe it can be turned into a business advantage. So I'm going to try and respond this question by my presentation today. But in order to respond, first we need to understand what sort of issue are we tackling and what is the environment around us. When we talk about tax disputes, undoubtedly everything starts with a tax audit. So we've talked about the stats already, and I'm going to probably repeat some of the data, but probably will mention some new. But when we talk about the trends of tax audits and figures, the State Tax Administrator announces we see for 23 and 24 and 9 months of this year. I've tried to present extrapolated data and to show that if State Tax Administrator will continue working at the same pace, what we'll have at the end of the year. So we're looking at the tax audit figures from 23. We can see that the figure remains on the similar level with a very small growth at the end of the year. And the question is, and also the State Tax Administrator says, that usually it applies the most strict measures to non-compliant taxpayers. Otherwise, they do not go as deep into tax audit. And the number of other control measures have grown quite a lot. And on one hand, it is good. And when we talk about the tax dispute process, the question is, what is that tax audit? Because practically, if you address a person or a company how they feel during the process and whether they could tell the difference between the different measures by the administrator, and when we ask our judge whether we can appeal against softer measures, they would say no, but the recommendations can be discussed and agreed upon. So the question is whether these procedures have been regulated correctly and whether we have the balance of rights and obligations. And let's remain with the conclusion that although the inspections are quite multiple, and we do understand that taxpayers have to be checked, the question is what are the results of these tax inspections? In 2023, we had 23 million, and 24 the figure grew and doubled. And in 25, I believe it could reach 75 million, at least I prognosticated so. What hides behind that? Of course, active involvement of tax administrator. Probably quite a lot of us have seen situations where tax administrator has become quite creative. They come up with new taxable situation. There are, of course, a lot of new rules, anti-non-compliance rules, and also we can see the trend to change regular practice on thin capitalization, etc. We do understand that this environment is very difficult and it scares a taxpayer who needs to take the decision to complain and appeal against the decision or not. So I'm sorry, I went a bit too far without explaining the disputes statistics. So the data of the Tax Disputes Commission looks quite impressive, and we see that over the period of 5 last years, the data show that a portion of decisions taken by the Tax Disputes Commission for the advantage of taxpayers grew up to 46%. However, we always have a however, this portion also accounts for decisions when a case was returned to be reheard by the tax administrator, which means that probably the tax administrator was not as effective. And also decisions in which the interpretation cannot be changed, but with the reduced penalties and late payments. And I wouldn't attribute such decisions to the decisions in favor of the applicant. Therefore, I believe the results of the Tax Dispute Commission should be revisited, looking at other sources again. And talking about the 95% that we've heard several times, and this figure is heard over and over again, I could not find data on 2024, and this is the data of State Tax Administrator on dispute results on the level of Supreme Administrative Court. And I don't think that this year is going to change the result very much, and the result of 23 was only up to 5%. So it's not the limit of decisions which are not in favor of a taxpayer. So knowing the reality, because it's a lottery and because everybody asks, do we have any chance to win? And when we make decisions, we usually look at individual situations and circumstances and legal arguments rather than statistics. Nevertheless, disputes continue, and we are talking about having more of them. But the process is lengthy, and it's not a problem in itself. And of course, it's better to take more time and get better quality decisions. But the problem is that over this process that can take 2 years, but probably not anymore, if a dispute needs to go several more rounds, and sometimes it's 7 years, so it's plus 11% of late payments per annum, which is quite a negative thing. And then, of course, you have to pay legal fees. And even when you win a case, only a portion of the legal fees can be recovered by the taxpayer. And having in mind that during the audit procedure, taxpayers quite frequently require legal assistance, and they don't even think about the costs back then. And auditors of companies quite frequently, when they assess such difficult statistics or difficult situation shown by statistics, they demand to defer some payments in accounting, which is also quite a negative result. And of course, taxpayers try to find ways out, and they quite frequently use the possibility to come to terms with the state tax administrator. This is a good measure, but probably not in all cases. and talking about the tax dispute and as a measure to design a more sustainable system, these situations do not help much when the interpretation question cannot be questioned. And it's sometimes difficult to explain to the client because they ask, am I guilty then? And you say, no, you're not guilty. But why do I have to pay this additional money, they ask. And of course, it's not applicable to situations which are long-term, especially when we talk about the business model and applicable tax rules. What's next? The problem remains in the system. And sometimes we can think that it's quite an erroneous system designed within the state, that you can agree upon something instead of being compliant or disputing. Of course, it provides funds into the budget, but at the beginning of the conference, we already agreed that taxes must be paid to the budget, but no more than you should. So where is this line? So it's only natural that when we have such unclarity, conscious business wants to know in advance. And for that, we have a good tool that obligates the administrator to provide a decision in advance. It's good, and it's a good guarantee if you manage to do so. It takes time, again, about a month, and it's not applicable to all situations, because if you have to already move with the transaction, you don't have these months in reserve, and there is no guarantee about the result. You might even receive positive or negative decision or response, and every now and then a taxpayer can receive a rejection to take the decision. And we've seen that trend repeating, and the court already, in my opinion, said that such a situation and such a response from a tax administrator can only be provided only for future transactions. But probably the rules are not very clearly regulated, because every now and then we see the decision that the decision is not going to be made because there could insufficient economic logic for such a transaction, and these grounds are not a part of the rules, and seemingly we need more clarity. And especially with mandatory or obligating decisions, when you receive a negative decision, you can appeal against, but it's not a tax dispute, which means that from the process we are taken out the commission, which is the only specialized institution, and the courts look differently whether to hear the case on the merits or procedures. So we need more regulation. But going back to practical aspects, the question is what else could motivate taxpayers to become more involved and initiate without fear tax disputes, because they are the catalyzer of the process. As I said, unclarity and also not being sure what's going to be the outcome scares a taxpayer. We can think about tax insurance. What is it, and why are we talking about tax insurance with tax disputes? Of course, it's not an alternative to tax disputes, and however, tax insurance can insure against a certain tax risk in a certain situation. for which a tax administrator can undertake a tax audit and calculate certain penalties or late payments. So this can be insured by the insurance company, including the legal fees. So that helps a taxpayer, and that helps a taxpayer to transfer financial risks onto an insurance company. So it's more security for a taxpayer. But this instrument, I should say, is not in cases for non-compliance. No insurance company would agree to that. So how this instrument could contribute to tax disputes and improve them, financial risk is handed over to insurance company, and they can also contribute with legal arguments, because first you would have to go through the filter of the insurance company to find out whether your arguments are sufficient for an insurance company to believe you, so you could win the case. On the other hand, when an insurance company undertaking the risk, they become interested in the final result of the dispute, and in case of a dispute, they contribute with their legal assistance. So it's not only financial, but also legal support. So this instrument is actually very disseminated in the West. Internationally, it's so-called hygiene norm, and Central and Eastern region, it's becoming more popular. In Bulgaria and the Czech Republic, and it's arriving to the Baltic states as well. And the most popular risks, and you'll probably see quite a lot of similarities in Lithuania. So tax at the income source, then price making rules, CFC rules, and VAT classification. So what could we insure against? Everything under the control of state tax authority, which can have different interpretation. So dividends are on top, and thin capitalization, we'll hear from the colleagues about it, reorganization, etc. So I do hope and I believe then from all my insights and insights of my colleagues in this conference, the state as well as taxpayers are going to find ways to contribute to improving the tax dispute process in order to have more clarity in our tax system.
Tai ačiū Indrei.
Thank you, Indra. I'm only interested if any insurer could win, if any insurer would like to insure a tax dispute. We don't need to think about it. We already have this on the market, such insurers. Thank you, Indra. Another highly relevant topic linked to a specific category of taxes that are customs rules and regulations and application of customs legislation. This topic will be presented by the expert of the topic, Dr. Gediminas Valentiejus. Honorable participants of the conference, thank you for the invitation to the conference. I'm grateful to the organizers, and I would like to share my insights as a practitioner and as a representative of the academia, because I'm representative of Mykolas Romeris University, law school at this university, I will present the study that has been carried out at the university. And I would like to speak about rather specific, but at the same time very relevant area of tax disputes. Those are disputes relating to the application of customs legislation. We know that we have several tax administrators, like in other EU member states. We have the State Tax Inspectorate, but we also have another institution which is pretty separate, and it works as a statutory service, that is the Customs of the Republic of Lithuania, which administers import taxes, customs, VAT, excise duties, trade protection fees. And in my presentation, I would like to take a look at what problems of application of EU law results in problems not only in Lithuania, but also in the other Baltic states, in Latvia and Estonia. And I will speak about what happened over the past 5 years, starting with 2020 to 2025, and why this area in particular is so relevant. I will be brief. It's not because that it is very complicated or it has specific sources of law which apply, but just like other speakers said, that we can observe the trend that number of tax disputes is going down, but disputes related to application of customs legislation or import taxes are broader in a strategic perspective. Looking through the perspective of the EU, let's say, adoption of certain EU laws and legislation will affect this. And we have more and more disputes in this area because this area is becoming more complex, more relevant, and it attracts more and more attention. And it has to do with the fact that we have some trade, the Institute of Trade Wars, when global states, and including the EU, is defending its commercial interests by introducing higher customs rates, and which are being disputed by the business more and more often. Various trade protection measures are introduced, such as Trump's taxes, and application of various international sanctions. Sanctions, of course, are not taxes, but since there are more and more international sanctions introduced, so the goods which are subject to customs, to excise duty, they are inspected more often, just to see if international sanctions are not evaded. So there may be fines, not necessarily for infringement of sanctions, but for failure to complete certain customs procedures. So there are various contested situations in this area. When it comes to my presentation of how I would like to present the situation in the Baltic states, not only Lithuania, so I would like to take an overall look at the problem because of not unified application of EU customs law. And when it comes to application in the Baltic states. So we have different aspects, and national courts refer to the European Court of Justice for asking for interpretation of certain norms of EU customs law. And we see what specific problems every country has related to this interpretation of customs law. And we may also identify what is typical of, let's say, Lithuania, Latvia, or Estonia in the situation. We can make a comparison. So first of all, I can say that over the recent 5 years, at least during the time of the study, there were 8 cases involving the Baltic states related to application and interpretation of the EU customs law, where European Court of Justice was referred to by the Baltic states, asking to interpret certain provisions of EU customs legislation. Most cases come from Latvia, what we have observed in our study. In Lithuania, maybe because of our legal tradition or maybe of our legal environment, different environment, so we have fewer referrals. Estonia always had very few referrals, but Latvia, for some reason, they had most of the cases referred to the European Court of Justice. Estonia only referred to the Court of Justice once regarding customs law, and we only found one case over the past 5 years. While in Latvia, they have most problems, as we see, and fewer in Lithuania. So it brings the question why. It may not only be related to the legal tradition of the country, but also it may be related to certain national procedural legislation, various procedures for inspection of customs and etc. that we have in place. So that is my observation. When it comes to the case law in the Baltic states, there haven't been many studies on this topic, but the case law of the Baltic states has attracted the attention of some authors, let's say in Germany. Limbach has analyzed the case law of the Baltic states in her studies. Certain Latvian authors analyzed this, but they have they all highlighted that we may see certain specifics related or attributed to the Baltic states, and which is only typical of our region. Going down to the essence of those problems which may see, while conducting the investigation on the problem of uniform application of EU customs law in the Baltic states, I may distinguish one specific problem, that is determining of the customs value of goods. And why is that? It is the background for calculation of import law. It is regulated by the EU legislation, by the Code on Customs of the EU, and the application should be clear. But the practice is that member states, such as Lithuania, have their own national rules for defining this customs value of goods, and have their own national databases, where you have to compare this customs value of goods with the market value, etc. So what can be observed from the Court of Justice and the cases that have been referred from Lithuania to the Court of Justice, that the Court of Justice has stated that it is not always clear for the tax administrator and for the courts how this comparison of customs value of goods be ensured. Let's say how you can ensure that you compare the same good, the same item, and not two different items. So in the case law, there is such an explanation, but it is not clearly defined in the legislation. So that is something which may be seen as the problem of the EU, that the regulations are not completely full, or not regulate everything to the fullest, and that the rules in Lithuania are also rather abstract. When we take a look at Latvia and Latvian situation, Traditionally, they have many disputes relating to customs laws related to classification of tariff goods. What is the classification of tariff goods? That is a specific concept for non-experts, that every imported or exported item from the EU may be and is attributed to a certain code. And there are some 10,000 codes, and based on that code, you can identify which import duty applies. So that classification is regulated by the customs legislation of the EU, but the application of those rules in the national context raises various fundamental questions. And those questions repeatedly rise in Latvia. In Lithuania, we do not have that many over the past 5 years. But in Latvia, we see this trend. So questions such as how goods should be classified by the objective description of those products, let's say items. We had a case about the copper products, classification of copper products. So it's kind of like was identified, code was automatically attributed, or should you take a broader look, whether it's according to the purpose of the item? So the European Court of Justice has stated that there should be a broader look. That's not only the ingredients of the item are what matters for tariff classification purposes. So then this rule is not completely clearly reflected in the EU combined nomenclature, which provides the general rules for interpretation. Shouldn't it be improved or amended? And another problematic question arising from the case law of the Baltic states, and we may identify this, let's say, should we only rely on the EU legislation based on for classification, or should we also take into account the international documents such as by World Customs Organization? It's kind of a superior organization and it should have superior legal interpretation, but it is not the practice. And the European Court of Justice has stated that those interpretations of the World Customs Organization may be applicable only in certain cases when there is no description of such an item in the EU legislation or in other specific cases. So then there is a question. So all those rules only are in the case law, but maybe they should be defined and described somewhere else in some legislation so that we know how to apply them in practice, because this combined nomenclature does not really regulate this problem, and it is obvious. Then there's a question based on the Baltic practice. Should we classify those goods, let's say, if they are imported or exported as disassembled goods, or should they be classified as a set according to one code, or should they be divided into separate elements or ingredients and under different codes? So the Court of Justice, in a case from Latvia, has stated that a liberal approach should be applied and classify those items as one product, as one set, if possible. So then we also have a question whether those rules in the combined nomenclature are clear enough for the application in national states. Going towards the end of my presentation, I would like to draw your attention to certain procedural questions arising from the application of customs law, judging from the cases of Baltic origin in the Court of Justice on the application of those laws. So we have this case in Estonia, and we also had a similar problem in Lithuania, where applicants were arguing whether the customs applied the maturity terms properly and when, let's say, this right to redeem certain duties is still apply. So the VAT law in Lithuania on VAT calculations were not properly formulated and did not convey EU law clearly enough. So then the question regarding those maturity of terms or when the debt to customs expire and how they are regulated in the national legislation. We had similar cases both in Estonia and in Latvia. So shouldn't it focus more on harmonization of those provisions and those norms with the EU? We still have these discrepancies and gaps. A few more things that I would like to notice. Cases from Lithuania, Latvian, I'm sorry, case C376, which touched upon this question of substance over form. Customs is a tax administrator in our case, and when there is a dispute with customs, it is often said that there is such an interpretation, and I have seen it in the practice of Lithuanian Supreme Court, where it's said that the customs matters are strictly regulated, and you can only base yourself on formal completion of documents and not the form. But in this case from Latvia, the European Court of Justice stated a bit differently, and they said that, if the documents were filled in properly in the registers, so there are no serious doubts, and taxpayers' expectations should be ensured in such a case, and it should be treated according to the principle of legitimate expectations of a taxpayer and not only formal existence of the documents. So this is the position of the European Court of Justice. So this is something to think of for the legislator or the courts in Lithuania, whether the former regulation in this area was clear enough. And to complete my speech, I can only emphasize this. If we take a look at this period, over the past 15 years, since 2010 to 2015, 25, what problems we had and what problems remain in the Baltic states. So this tariff classification of goods still remains as a problem, and we often refer to the Court of Justice for this reason, which also remains problematic. That is a determination of customs value of goods, while other questions which were problematic, such as origin of goods, burden of proof of origin of goods, which we had in the past, they are no longer relevant, or they are not so relevant anymore. And they are questioned less often, or there are fewer references to European Court of Justice because of those problems. There may be various reasons for that, but the situation is changing a bit on what's relevant and what's not. So the study is very broad, and it entailed many details. So if you are interested in this, there is such a scientific and practical publication where the results of this study were published. You may find the link on the screen. And thank you for your attention. If you are interested in addressing these questions, please contact me.
Ačiū labai.
Tai ačiū Gediminui.
Thank you very much to Gediminas. And without further ado, let's go to the next important subject, which is going to be undoubtedly discussed: the rules of thin capitalization and nuances and related disputes. And we'll hear from attorney at law Andrius Paulauskas. Hello, everyone. I'm going to start with the topic of the conference, tax disputes and points of improvement. The best improvement, I believe, that we would not have to talk about this topic at all. I'm going to talk about the legal norm that has been in place for 22 years. We had several court decisions, and we have the commentary of tax law that has been issued. Of course, it's quite questionable in terms of quality. And every now and then we have to return to the topic. So hopefully, after the second round of courts, we'll finalize the issue and we'll never return back to it. So for the very beginning, maybe not everybody knows what is thin capitalization. Thin capitalization norms prohibit through the fact that loan interest cannot be deducted, they become capital. So I believe the essence of these provisions that over certain schemes, when lending money to the company, we can take the money to reduce the profit. So we have to make sure that the profit in this way would not be reduced, on which the tax is calculated. So money that is lended, we used to have a situation when it was not taxed by personal tax. Nobody wanted to increase the capital of the company, and later, of course, we changed the rules, and these tax advantage situations can arise when money is lended from abroad and there is a lower profit tax rate applies. So we have Article 40.3 of the Law of Profit Tax. I would like to draw your attention to this particular article because it talks about price making. And this article has a sentence which says that the government can set the rules anew, which sounds like about nothing. So when we talk about the rules, it's hard to understand it from this sentence. But Government Resolution number 1575 of December 9, 2003, which says that when the proportion of borrower capital from a controlling lender of a Lithuanian entity exceeds the ratio of borrowed capital to fixed capital of 4:1, interest is not a deductible expense. And there is an exception if the Lithuanian entity proves that the same loan would be granted under the same loan terms between independent persons. So we have an explanatory note which indicates that this norm is taken after recommendations that establish that this norm is to fight tax evasion. So in practice, we have these provisions, but they have not been applied for 10 years. And up to 2013, everybody understood that if you borrow on the market prices level, you are safe. But 10 years later, State Tax Authority started audits and supplemented its commentary and indicated that a taxpayer must not only substantiate the fact that interest corresponds to market price, but that the loan on the same conditions would be provided of independent persons. So it narrowed down the exception when the interest could be deductible from profit, and I believe to the point where it's impossible to prove showing that the same loan on same conditions. So maybe I can come back later to this point, but if a loan is tied down to Euribor, 3 months Euribor, you basically cannot prove that the same loan on the same conditions would be provided, because Euribor changes every second. So even if 2 transactions or offers are issued in 2 minutes, then they are different, formally looking at the situation. So we have 2, let's say, cases, my colleagues and mine, and as a state tax authority lost them, and the court made the decision that it's insufficient to identify the ratio 4:1, and there should be the tax evasion fact identified. And another important conclusion was that if you still increased interest and you are not paying the interest level on the market level, so tax administrator does not correct the entire sum, but only the part that exceeds the market price. So these 2 decisions, and we can dispute about the position, whether that's sufficiently grounded or not, but taxpayers cannot start a second round if they lose, and a tax administrator can actually start a second round of courts. So another case is company Ūkis, when the administrative court made a different decision, where the process was renewed and the Supreme Administrative Court annulled the decision as non-correspondent to case law, and refreshed or retried the case. But the company went bankrupt and was liquidated. Here, there is a very important process argument and motive, because the state tax authority says that it's about practice, but in my opinion, it's not different, because the decision which says that thin capitalization does not require the proof of tax avoidance or tax evasion, the court did not hear the case to the end, but the decision has been annulled. Ten years later, I also wanted to say that 10 years later, the tax administrator reopened this issue again. But what happened within those 10 years? There's the Anti-Tax Avoidance Directive that passed, which has the interest limiting initiative. We know that they cannot exceed 30% of EBITDA, no more than 3 million euros. So if interest is up to 3 million, it can be more than 30% of EBITDA rule. So I believe that this provision resolves the issue of thin capitalization rules, because the directive has been passed, and on the level of the EU, we have a regulation and we can close the issue. But no, the state tax authority upholds the oppositionary view, and they say that the directive and the law indicates that national rules can be stricter. Yes, it is so that national rules can be stricter, but the directive and the law and explanatory note to the law indicate that the rules are related to tax avoidance. And the key argument of the administrator says that these rules are not for tax avoidance, and that you do not have to identify the fact of tax avoidance. So what do we have? We have a norm which has been with us for 22 years. We have different case law, and we don't have any explanation from the state tax authority on the application of the rule. So the only position of the administrator, I don't know whether that's administrator or maybe Martynas Andriaitis can comment on that. I don't know whether that's the official position of the administrator or not. We need a very clear commentary from the administrator. If they believe that Ūkio case was something that changes the rules, they will continue applying thin capitalization rules, but we don't have any explanation. So Supreme Court, Administrative Court case, Baltic grounds, the European Court of Justice position was upheld, that you need to prove the aim to avoid or evade taxes. So this practice or this case law remains the same. So what do we have? We have this non-determined situation and clarity. And I believe there is this unsubstantiated requirement to taxpayers. So we have not been applying rules for 10 years. We don't know how to do that. We start audits, lose cases, and after lose cases, the explanatory documents are not adjusted. When the case is lost or the company goes bankrupt, we do not revise the commentary. Then we start audits with the second round of courts. So maybe in a couple of years we'll already have some decisions made by courts. And then about the selectivity to someone who takes part in audits, it still remains unclear in what cases the administrator acknowledges that the same loan or the loan would be issued under the same conditions, and because it's different decisions every time by the administrator. Sometimes the information is sufficient, sometimes it's not all conditions have been named. So there are many different conditions that can be applied. And the last question, on whom the burden of proof falls. So if maybe if it's tax avoidance, tax administrators should just go and select those office. So one situation when the loan interest was 8% and taxpayer says I have 12 offers or maybe 15, and I say they don't give all these offers, they are not the same, they're different. So they thought that the administrator will benefit from that, and the administrator says that no, they are different, it's not the same. But for the tax base to be reduced even more, nobody cares about that. So it's very formalized. Thank you.
Ačiū Andriui.
Thank you, Andrius. A very interesting topic. We will continue on this, I believe, in our discussion time. Now we have another presentation to hear. Colleague, a lawyer, an attorney at law, specializing in taxes. He will speak about what happens when the tax dispute ends, especially what's the responsibility of the head of the company. Good afternoon. Thank you for this introduction. Thank you for this invitation to take part in this conference. We have a rather interesting situation, both in practical terms and in the law application terms. After the tax dispute ends, where we move to a different playground, and from administrative process, we move to a civil process, civil proceedings. And why I wanted to touch upon this topic, that we see more of such cases, more decisions on these matters, when liability of a legal entity is shifted onto the person, on the managing person of the company. Sometimes it is the board, but usually it is the director of the company. So as lawyers, we probably think we should not interfere in these situations, but these situations are happening, and the way we see situation is probably different, and I will try to present likely challenges, likely perspectives. I will not definitely give you any assessments or will not propose any solutions, because it is only something that's starting and that it is ongoing, it is in the process. We don't have a complete case law, but it is rather interesting. So in general, what the Court of General Competence says when they receive a result of a tax dispute in the next proceedings. So what they say, that direct actions against the manager are only apply in exceptional cases, and they are apply in extremely narrow area. So this means that we have a very specific, we have to specifically name the creditor, we have to name specific damages, and define the actions which are against the law. We have to define the damages, the causes, and prove the guilt of the manager. Alongside, the court also takes into account a few more aspects. They have a position on the tax administrator, saying that it has a greater power of proof, that they have written documents, which brings more challenges to the other party to challenge such a proof. And another aspect, that facts indicated by the State Tax Inspectorate are not preliminary facts. So we have this playground where we have the case and the parties in it. The case law is built in cases largely relating to VAT, and in tax disputes, the taxpayer, let's say, fail to pay their taxes because they go bankrupt or their activities end. This is why the tax administrator initiate the recovery. So I will try to speak about the triangular trade, about the application of the reserve rule, because likely tax damages create interesting assessments in the civil law field. So to be brief, when we speak about VAT, we say that VAT is paid by the buyer of the good. If the goods are transferred outside the border, we reverse the VAT rule. We call it as reverse VAT, and we say that it is paid by the seller. So taxation of intermediary is the problematic one. Sometimes they make the procedures easier. They minimize the administrative burden, and in certain cases we have a simplified option. Goods, let's say, like in this scheme, they travel to a buyer C and VAT is paid there, and they have a creditor there from the perspective of civil proceedings. And we have a number of requirements for that. They have to be met. If those requirements are not met, then we have a question regarding the payment of VAT. And it ends up in paradoxical situations. The creditor in that country is not even asking whether VAT was paid or not, while the intermediary, company B, and the tax regulator of that country is raising this question and asking whether VAT was paid or not. And we have two creditors in this case. The question is which is primary, which is secondary. But the situation is interesting. What else is important in this situation is that the manager's possibility to control payment of VAT, and that is an obligation, but they are not absolute, because every business has limited possibilities to check and employ the information in order to assess their partner. So it's well, a similar thing applies in Lithuania. We have a partner. We keep checking that partner. Sometimes that partnership lasts the entire life. Sometimes we have to divorce. So a similar thing applies here. We divorce, but we still need to pay VAT. So in triangular trade, the situation is a bit simpler. When we speak about the application of the reserve rule, then we have a process with 4 angles, but still VAT has to be paid in the country of the buyer. In a given situation, we have point D, let's say Polish VAT payer, where VAT has to be paid. The rule of reserve introduces additional burden to intermediary, that is B or C, to prove that VAT in point B has been D has been paid. Lithuanian tax administrator holds the position that that is the obligation of a taxpayer to prove this, while the law defines it differently. That the duty of proof may be transferred to one or the other of the parties. And well, in the law, it is said that it may be proved, and it does not define the obligation. So in this situation, we have an interesting aspect that the civil proceedings, which requires to prove damages to the creditor in a tax dispute, it's not understood as per se. In a tax dispute, we speak about payment or non-payment of VAT. It's not so important in which country. what is important, whether the EU budget or the budget of some member state does not suffer from failure to pay that VAT. Yes, we may have a problem of improper payment or accounting of VAT. So we are simply taking into account whether it's had been done in good faith, honesty, care, and prudence. Whether such a thing exists from the partners or not. If it exists, the situation maybe it is easier, maybe untaxed role of the intermediary is enough, and if not, we may end up with the result in a tax dispute that VAT applies to the seller but not the buyer. In civil proceedings, we don't have that. We have to prove individual damage to a specific creditor, the harm party. So the question is how in civil proceedings we can tell if there is a creditor who has been granted a right to recover that VAT, because in the rules we say that the buyer has the obligation to pay VAT, but we have a situation in the case that it has not been proved, and the tax administrator cannot prove this because they cannot get this. Taxpayer cannot prove this because he cannot get this information about his partner. He only may check this indirectly. The tax administrator also says that we don't have this obligation. Then we end up with a situation that without having established whether primary creditor has any claims regarding the payment of VAT, other creditor, in our case, the intermediary, the regulator of the intermediary, is raising the question about this fulfillment obligation or payment of VAT in Lithuania. So in this situation, when we speak about the taxation of the creditor's role in tax dispute may look one way, while the creditor's role and possibilities in civil proceedings may change. And why it may change? This brings us back to primary positions and what our cassation court has said. That the creditor has an exceptional possibility, and that is a requirement which is applied in a very narrow area. And in this case, we have an official document by the party of the dispute, a written document. And then we have a question of good faith, whether the party of the dispute, which has filed a document with information and claim about the calculation of taxes. So the question is whether this party was honest and completed all of its obligations in the civil proceedings. So the question is whether the rule or a reserve rule, and in case in triangular trade, whether the party of the dispute has learned if it's truly a creditor, or maybe in the tax dispute, the taxpayer who has been calculated the claim or attributed the claim could have known about the creditor and illegal actions which bring damage to a certain creditor. So what challenges are ahead? Given the current situation and the position of our cassation court for the parties of the dispute, we will probably face naming of a creditor in civil proceedings, and it may not coincide with the creditor in tax case. We will have to take the burden of proof and different assessment of this burden of proof, because some requirements in civil proceedings may be like easier for one party, for taxpayer, for tax administrator, than in a tax case. Another aspect, since we have the decision of national tax administrator, which is believed as it was treated as an official proof and official document, for such a written official proof the question of competence is raised. So question is whether a public authority, state tax authority, by adopting the decision, did they fulfill all their duties and obligations in order to get such a decision, including acquire information from their colleagues abroad about the goods in question. And the eventual question, which brings us back to the good faith doctrine. In such situations, this doctrine of good faith is very important. How fair and how was the party in the entire civil proceedings. I'm sorry, I'm pressed for time, so that would be it from my presentation, from my side.
Ačiū kolegai Dainiui. Ir
Thank you to Dainius. And next we'll hear the last presentation for the day from the Tax Disputes Commission, and the member of the Commission, Jurgita Narkevičiūtė, who is going to introduce a discussion topic, the intersection of legal branches, practical problems in tax and criminal proceedings. Thank you very much. I'm happy to have this opportunity to talk on this interesting topic. We discuss it quite frequently among us colleagues, but we would like to have a more wide analysis. State tax authority and Customs Department, Financial Crime and Investigation Service and other bodies act separately, and some institutions are controlled by one ministries, others act independently. Cases are heard by specialized or general courts, and we have this mismatch of understanding. So today I would like to talk about intersection of legal branches, practical problems in tax and criminal proceedings. Back in 2005, the Senate provided the resolution number 55, in which it explained on the case law on criminal offenses against the financial system in criminal cases. That criminal cases where the offender is subject of the legal relationship of tax administrator, taxpayer, and material damage of the state was caused by criminal acts specified in certain articles. And then it seems that the relationship between these legal branches have been established, but let's look how it looks in practice. My first tax situation that I'd like to introduce to you is for a CEO and shareholder was provided with some charges, and the CEO and director were said to have collided on profit and assets, and they took them for themselves. And the investigation took place for 2006. It was undertaken by the Financial Investigative Service. And what happened then, after the case went to the court, the pretrial investigation was looked at by a local tax administrator, and following the law, Article 68, calculated to this legal entity the VAT, profit tax, and excise duties for the period from 2014 to 2016. The local tax administrator calculated late payments and penalties. And during the same investigation, there are two procedures initiated. During pretrial investigation, local administrator undertook the different roles. And in the criminal case, the specialist decision should be the same as the act in the other role taken by the same institution. So when we look at the same factual circumstances, there are conflicting circumstances that were found. Talking about this case, we should draw our attention to the fact that tax administrator did not undertake a separate investigation. They looked at pretrial investigation materials, used the data, and the tax administrator has such a right according to 72nd article of the tax administration law, and then describes all the situation in the respective document. So the company, when they complained about such actions of the to the central administrator, they have certain decisions and corrected them, adjusted them in the next stage. So if we talk about this case, I would like to draw attention to the fact that probably you noted that during pretrial investigation, all the charges brought against the company, the natural persons, and then in another decision against the company. So when looking at this entire situation, the Tax Disputes Commission had questions whether in such a case they do not breach nobis in idem's principle, because the decision is taken against the director and a natural person as a shareholder, and they undertake a certain confiscation of assets. And then additionally, as a legal person, a legal entity, the entity pays penalties and late payments. So the Commission decided to stop looking at the case because they wanted to wait for the court decision. And this case was very interesting because the application was not confirmed by the court, and it was returned back to the administrator. And there was a subsidiarity principle applied. So during the criminal course, the civil plaintiff was a company as well. So we return back to the first question. What about the double penalty principle? When we have one pretrial investigation and we have such decisions. For quite a while in Lithuania, we thought that the obligation to pay taxes arises according to the tax laws and criminal according to other laws that regulate certain situations. So I wanted to raise a question whether the question on the chosen instruments by the administrator and it needs to use principles that, although we have additional provisions that were adjusted in the law to pass on the cases to the Financial Investigation Service, Financial Crime Investigation Service, and ultima ratio has to be applied. And this principle has to be the basis. So tax administrator should not initiate additional pretrial investigations. Another slide, and I'm going to talk about illicit enrichment. From the General Prosecutor's data in 24, we had 22 such cases, and 22 acts of illicit enrichment were registered, 6 of such acts were investigated, 24 pretrial investigations were completed, 17 were terminated. One case was transferred to the court with the prosecutor's statement regarding the termination of the proceedings by a court penal. And there were also a decision on high standards in such cases. And the crime code also Article 189 applies, which is also established in tax administration law, Article 70, and it's a very difficult task which requires collaboration between the taxpayer and administrator. And in order to avoid difficulties that are indicated in the General Prosecutor's report, tax administrator attempts to interview a taxpayer as quickly as possible. And I wanted another question to be addressed. During pre-trial investigation and court hearing, the plaintiff has the right to decide to give evidence and at what stage. And according to the administrator's rule, if you do not provide information, you are deemed non-compliant. And according to certain provisions of the law, there will be some aggravating circumstances that can result in higher sanctions. Another tax situation that I want to very quickly introduce, I would like to say that I have a separate decision in such cases, and it's not always that I manage to persuade my colleagues. Money found during searches. In all these situations, money were found. In first case, there was the conviction of a criminal offense of a corrupt nature. And in another case, there were special witness status. No charges were brought against the taxpayer, although the article that applied was 189 of the Criminal Code. And in the third case, all 5 members were involved, but illicit enrichment was not found. In the first case, applied extended confiscation of assets applied. In the second case, pretrial investigation terminated, money returned. And in the third, during the search, money found in the deposit account. Why? Because there was another civil dispute, and the court found that in the third case, it was nobody's money. And in all these 3 situations, what did the administrator did? The tax administrator, they always calculate taxes of the money that were found during searches, and sometimes can apply penalties as well. What's interesting is that looking at the decision of the appeals court, there was a moment of money found established, and the money was saved 5 years before 2010. In the second case, the prosecutor decision to terminate the pretrial investigation, the moment of receipt of the money established during the search, is considered to be before 2010. And in the third case, the money was ownerless, so belonged to nobody. So we still are waiting for the decision of the tax administrator, and sometimes it's difficult to persuade the colleagues that our Supreme Court took the decision in several weeks about the moment of money received, and this moment of receipt of the money should not be the moment of money found during the search. And the second case, the case is still being heard in court. And in the third case, I persuaded my colleagues to wait for a while, because if the money is ownerless, it's not going to be the object of taxes. So hopefully our colleagues will go back successfully home to Ireland, because you've heard probably that we have issues with balloons that carry contraband cigarettes, and according to the General Prosecutor's Office, we had fewer such cases, and also fraudulent accounting cases have dropped. Unfortunately, even though the cases are fewer, they are more serious, because we have to close down and shut down our airport. And my colleagues already talked about 104.1 article, and my question was, maybe we shouldn't initiate a separate case, or the question is, maybe civil cases should be, because cases are heard quite quickly, and contraband perpetrators quite quickly recognize their guilt, and maybe it's worthwhile to ask a question whether they should be heard according to the tax administration law. It's not only the tax according to the tax law, and so my last slide is just for discussion. I have a separate, probably, opinion on these issues as well in the dispute commission. In cases when the criminal case is related to asset confiscation or confiscation of ownerless assets, do we really have to levy tax on it?
Thank you, Jurgita. Well, our conference is coming to an end. We still have a few more minutes, and I hope you still have some patience and stamina left. So we have a few more minutes for our discussion. Just like I said, the second session of the conference was more like a combat one. It was based on fighting topics or topics for discussion. So a few theses or a few ideas from what we've heard today, I will ask to be active, not only those who already had a chance to speak, but everyone to express their opinions. In the first presentation, we heard this idea that this Institute of Good Faith in zero VAT cases is kind of unneeded, because it is additional burden to the tax administrator. We also heard this Institute of Good Faith mentioned in other cases, in thin capitalization, in criminal cases, and collision of criminal cases and tax disputes. So what is your opinion? Is this good, still good faith, still relevant? Is it still needed, or is it too cumbersome in our life? honest or not honest, you still have to pay your taxes because it is written in the law. Well, my brief comment as to honesty. We cannot deny it, of course, this concept based on the law and tax administration in Lithuania. We have this presumption of honesty in the law defined. If customers file their tax return, it is believed that it is, correct until the tax administrator proves differently. So taking from the electronic tax returns, 87% of all customers file their returns on time and correctly. So, and only very few raise questions due to their correctness. And the tax administrator's goal is to help, consult, and educate taxpayers and businesses to fulfill their legal obligations properly. But when it comes to specific cases, I think that even, especially in cases of zero VAT, and when we obviously see that goods have not been transported, or in some cases of thin capitalization, we should probably not talk about some abstract honesty, but the need to prove it according to certain data. And in 0% VAT, when we see that the goods were not transported, and if the buyer has certain documents or not, and if they are applicable to 0 VAT or not, and simply not to enter the discussions whether they are honest or not, if we see that they have failed to complete certain actions. While in thin capitalization, I suggest to cross out that paragraph number 7, which refers to this burden of proof, or either, like the speaker mentioned, to add a commentary to the to law on tax administration of how we can prove this match to the market price. So we should revise the specific criteria that we have and to follow those criteria and not to raise questions whether it's honest or not, and then we have this assessment nature. So my brief idea is such. Martinas keeps emphasizing documents, the list of documents, and the same thing has been highlighted by Gediminas Valentėjus. He was also talking about proof documents and specific lists of additional documents. And I had a number of cases when I had to deal with Scandinavian countries, Denmark, Sweden, Norway, Iceland. And their principle of general administrative management of documents, where they send you some document, and when you ask, what is this kind of document, they say, oh, it's an invoice. So do you have an agreement? So let's start that the invoice is like 1.5 million worth. And when you ask for agreement, and why do you need this agreement? We agreed upon by email. Signing an agreement. Why these formalities? We are honest. We are doing everything well. So they don't even imagine what a list of documents, this list of documents like we have in Lithuania. And if you ask them to provide all these documents, if you ask some Scandinavian company, they wouldn't understand half of the points that are included in that list and what they are asked for, because they don't even imagine that someone may be dishonest. And I had a number of situations when we could see there was a tax inspection happening, and clients had no documents at all, nothing, and even a bad invoice. And there were no questions if the goods left the country or not, if they were sold or not. This was the case of 0% VAT. And the tax administrator asked, do you have documents? And they said, no, we don't have anything. We only know the buyer, and we have this invoice. And they have no problem about it. While in other cases, there are piles and piles of documents, proof of honesty, and still it results in endless disputes. So this is a question for discussion, you know. What is more important? Is it this true honesty or all those lists of documents? Or having those full lists of documents and ability to prove everything in the zero VAT or thin capitalization rule, but not to have this criteria of good faith, of honesty. Grateful to the organizers for such an interesting conference and interesting presentations. As to thin capitalization, in my personal view, maybe I'm a scientist or former scientist. So this decree by the government is against the constitution, because thin capitalization relates to the tax base definition, and I think that these rules, and as we speak about proposals to the legislators, they are totally obsolete. They have very strange provisions, and when it comes to thin capitalization, the main problem that it has, and the court has stated that first of all you need to establish fraud and honesty. Then maybe they change their mind. The commission of the tax dispute, they also changed their mind, and yes, maybe they tried to prove a fraud in the beginning, but now they are no longer thinking about this. But there's little clarity on this. The saddest thing is that in the case of thin capitalization, we don't have any support from courts or from other dispute institutions. That it could be a matter of transaction pricing, and the same loan under the same conditions should be provided among natural persons. Unfortunately, I believe we are late in this process. Maybe case law could change. It's not carved in stone. So we see certain changes. I believe we could avoid such discussions about honesty. When it comes to honesty in zero VAT, that's not an invention of Lithuanian. The Court of Justice has said, and in customs case, Court of Justice has stated, and Lithuanian customs did not really accept this novelty of honesty. But this case, I think, was some 7 years ago, and it was stated that you have to analyze whether the provider or businessman was honest. And honest entrepreneurs are defended by the EU law. If you have done everything that you could do within your means in order to protect yourself from these situations, so then you have a right to use those provisions of the law, including the 0% VAT. So there are many circumstances to assess. So there are too many of those assessment type circumstances in tax disputes. Whether your transactions were in line with the tax logics and etc., in business logics and etc. If was it in line with logics or not. So these are assessment type, honest or dishonest. This is also an assessment type, questions. So we are probably entering a development stage when we have many assessment type circumstances, which does not bring more clarity. But tax laws have to be clear. Unfortunately, life is what it is. We have case law from the Court of Justice, anti-avoidance provisions, fraud provisions. So we have to learn of how to assess all these, I guess. I would like to thank Honorable Lawyer for confirming everything that the Supreme Administrative Court has been saying since 2013. We have put into a system everything that has been identified by the European Court of Justice, that, there may be dishonest taxpayer and they may be involved in fraud. And if they do so, they do not act as taxpayers. And then they cannot use their right to accounting or to exemptions. They cannot be exempt of VAT, and the same rules apply, both for fraud, both for abuse or evasion. So we cannot say that that is not included in VAT law. So it's not really clear why we have to assess this, because this is the case law of the Court of Justice, and it is similar in all member states. The provisions of VAT regulation have to be interpreted the same way in all member states, so we cannot go back to this and say that, maybe we do not need those documents, those agreements or something. And the fact that it is not included or defined in the VAT law, yes, it is difficult to determine those assessment type circumstances, but we cannot avoid it, and we have to do this. A few brief observations related to customs. And the moderator said, we have been discussing whether taxpayers need more or clearer interpretation with more criteria of how to apply those provisions. I think we have excessive information already. The case law itself, let's say the commentaries to the tax administration or VAT law. So there are thousands and thousands of pages of those documents. But with customs, there's such an interesting fact. If we stay away from tax administrator, tax inspectorate. In tax inspectorate's activities, we have a commentary on tax administration, but in customs legislation, we do not have any commentaries, and we do not have a database where we could have all the explanations by the customs department regarding the application of laws. We have a law on customs, but there are various rules defined for customs, but we do not have any commentaries to this law. So I still believe that such a detailed classification or clearer interpretation or creation of databases in customs is really meaningful and needed. You mentioned the practice of Scandinavian countries, but I had to face with the United States and tariff classification of goods, and we try to compare how they understand this in the US and how we see this in Lithuania or the EU. So I saw that they have rather detailed databases where you can find explanations, all the classifications based on the code, and then can be easily found and then determined. While we don't have this. So I think there is some kind of problem and nuance. And when I refer to classification of tariff goods, so we have some publications for taxpayers of how to understand those codes, but they are some of those publications are obsolete. They are 20 years old, and let's say I think they should prepare some new publications, to have new releases of those documents. So maybe they would even bring the number of tax disputes down. So that is my personal approach. from one member of the Tax Dispute Commission I have heard, and she, I think, was very right, but even though that was a very long time ago when she said that, some 10 years ago, she said something, she made an observation which is highly relevant in today's circumstances. So what she said, despite how detailed lists of documents and requirements we have, there will still the best ones who would, fulfill them best, it will be the dishonest taxpayers, because will be the ones who will pay most attention to this in order to be in line with those lists. So please think again whether those extensive lists of documents contribute to the solution of the problem or will make this problem even worse. So whether this honesty criteria is so insignificant, like my colleague Martina said. Wouldn't those long lists of documents make our job even worse? Because we may end up with the situation, the law lists all these documents. Here are the documents. So I'm honest because I brought all the documents. So I have to be subject to the exemption. Like in our discussions with businesses, they say that give us the rules of the game and then we'll see if it pays off or not. According to Constitutional Court, tax regulation has to be specific and clear. I would be in favor for those cases of thin capitalization and those specific criteria to be listed. And if, let's say, someone is not honest, but if they collect all those documents, probably that makes them honest. But if they are, of course, counterfeiting those documents, that is another category that brings administrative or criminal liability. But I think we should add up to more clarity for businesses. If I, let's say, I am in line with all those 5 requirements, I may be exempt of VAT. When the buyer is responsible for transportation of goods, but has no data and formally does not implement those actions, so there is a question raised to the tax administrator. The tax administrator had to take into account the honesty of the seller, even though we see there are no respective contracts or any data, and the goods remain in Lithuania. But since the buyer was the one who was in charge of transportation, we also need to take into account the honesty of the seller. Even though from the circumstances of the case, from the international information, we see that the buyer did not have those basic agreements. So in such cases, probably we should not focus on honesty, but see whether the goods were transported or not and the proof of that transportation. But when we have those abstract norms, when we have those rules of proof, tax administrator has to discuss as much as possible with business and to have those lists of necessities. Holdings and dividend payments, the tax administrator once listed all those requirements. They were criticized, those requirements were crossed out. And then we discussed this with colleague Andrus and with foreign administrators. Foreign administrators, they usually have those criteria in comments on how many staff they need, what is the capital, and what is the share between the own and loan capital, and what are requirements for holdings, 10 to 12 dividends paid, and they are not subject to tax. So I would be in favor of having that specific list of criteria to make it more clear both for the administrator and for businesses. It's good that we are having such a discussion. We will try to work in between these lines. Thank you for your presentations, for your opinions. Those of us who are tax lawyers, we know that these discussions are endless and they go on and on forever. But we need to have some topics to discuss next time. We will continue our traditional event next year. I would like to thank, first of all, to each and every one of our speakers for their highly professional and in-depth presentations, which raised some new questions for us, opened up new horizons, highlighted new problems, discussions of what could be improved or amended in tax disputes, in legislation, in case law, and the directions for our future in improvement. Let us hope that we will continue our work and we will analyze these problems in different perspectives. I would like to thank moderators for moderation of the conference, and I would like to thank also to all the organizers of the conference, Seimas Committee of Budget and Finance, and their representatives who contributed to the organization of the event, and colleagues from the Tax Disputes Commission who worked hard many days on organization of the event, trying to ensure to have a smooth event. So thank you once again. I hope that we will not forget about the problems we have raised today and will be discussed in new forms, in new discussions to make it clearer and more effective. Thank you once again for your participation, for being active, and see you next year. Best of luck in all your endeavors and in your personal life. Don't be afraid to argue and to defend your rights, because disputes bring clarity, and that is the way forward. We should not avoid disagreements where they can give more benefit and more light to everyone. Thank you.
Nuotrauka?